Good morning. The District Court of Appeal of the State of Florida and in for the Second District is now in session. The Honorable Craig C. Valenti, Judge presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court.
All right. Good morning. Welcome to this session of the Second District Court of Appeal. Obviously, this is a Zoom session. The appellate rules still apply. We still expect the proper decorum. The time limitations are the same as a live OA, which is 20 minutes per side. The appellant gets a brief rebuttal not to exceed 5 minutes. And there's a little bit of a lag between entering and exiting the video conference. So bear with us. And if someone has a problem with their Wi-Fi, then we will try to pause and resume when the problem is cured. We're going to call the case in the order they appear. So if the people for the first case, which is Pinkston, want to enter the box, please do so. That's going to be Foreman and Roscoe. All right. Is Hellickson for the state? You're on.
Yes, Your Honor.
Okay, I'm sorry if I called you Roscoe. Okay. Ready to go? Let's proceed.
Great. Good morning. May it please the court. My name is Jason Foreman. I represent the appellant in this matter. I would respectfully ask for 5 minutes for rebuttal.
All right. You got it.
Thank you, Your Honor. The case before the court this morning involves the partial summary denial of a motion for post-conviction relief, as well as the denial of a motion to correct a legal sentence. One claim was resolved via an evidentiary hearing that involves a sleeping juror. A little bit of background, the appellant was convicted of committing armed robberies of two different real estate agents in different locations that were reported to law enforcement about 73 minutes apart. The defendant's sole defense at trial was misidentification. He testified and explained basically the reason why it was not him. The facts of this case is a little unusual. The appellant was a businessman, no prior record, married for 37 years, apparently purchased a throwaway phone from Walmart, where he made back-to-back appointments with two different realtors located about 15 to 20 minutes away. With victim one, once he was inside the house, he put a gun on her, placed her in handcuffs, zip ties, demanded $50,000 from her husband using her cell phone. The husband pretty much told him to pound pavement, didn't believe him, and then he left. As part of his plan, he went to commit the robbery of the second victim. So he drove the same vehicle, met the second victim at the prearranged location, and just like victim one, he pointed a gun at her, demanded money, but by happenstance, some other realtors came in and basically ended that interaction. Now at sentencing, which obviously is one of my main issues, all the parties believe that the 1020 life law required that consecutive sentences be
Before you
imposed.
delve into that, because I think that is an interesting issue, is that going to be your primary focus? You got tons of issues in your appeal.
I know it's going to be my initial primary. It's going to take up a decent portion of it, Judge. Yes, and then I'm going to go towards the summary arguments.
All right, proceed.
But again, the facts of this case, my argument is that it was one criminal episode, and under Williams, you cannot impose consecutive sentences for offenses where it's part of one criminal episode if there's no discharge. This particular case, there was no discharge whatsoever. Defense counsel, Williams came out a couple of months before the sentencing hearing. Defense counsel didn't even make an argument that it was one criminal episode. But if you look at the record, it demonstrates that it's one plan, basically just two components of one plan. I mean, the appellant called the first victim at around 11:30 in the morning and made an appointment for 12:30. And that's on page 220 or 2276 of the record. Then the second realtor gave him a call back because he called the second realtor. She called him at about the same time, 11:30, where he made a 1:30 appointment.
Well, the question becomes, can these be two separate criminal episodes for sentencing purposes, but the same criminal episode for non-severance purposes?
Correct. Now, I'm sorry, did I?
Well, you said correct, but I think you wanted to say incorrect.
Yes,
In other words, you have a sentencing issue that arose from the judge believing the judge had no discretion to give anything but consecutive sentences, correct?
yes, sir.
And if you have a qualifying offense and a non-qualifying offense, the judge has discretion to give non-consecutive sentences. If you have two qualifying offenses, the judge must give two back-to-back consecutive minimum mandatories. And that's probably one of the state's arguments.
Yes, sir. But if it's part of the one criminal episode, I mean, think about it. He took a cell phone, made an appointment at 12:30, made a consecutive appointment for 1:30, committed the robbery, got in the same vehicle, same gear he was wearing, committed the second robbery. That's one plan. That's one transaction. That's one criminal episode. It just took time to take place. Kind of like, we see the buck.
Mr. Foreman,
sir.
didn't he make all these arguments in a prior 3850 motion?
Yes, I filed a 3850 in this case, Judge.
Or excuse me, right. And then now this is coming back for a second time on a 3800?
No, basically what happened, Judge, is I filed a 3850 and I argue that the court had no discretion because it was consecutive. It was one criminal episode.
Okay.
Then that was denied. The court said, no, that's not true. Then I filed a 3800 saying it was a motion to correct a legal sentence because the court misconstrued one of my arguments and said I was relying on the James case, which was obviously a case that Your Honor was on the panel in 2018. So I filed this kind of to hedge my bet. And the bottom line is if the sentence is illegal, it's illegal. So
Well, why is it illegal? It's
Because
not
it's-
illegal unless the judge was absolutely prohibited from imposing consecutive sentences. But if you have a qualifying offense, which you do in the armed robbery, and a non-qualifying offense, which you do in the kidnapping, the judge had discretion to impose consecutive. I mean, the strongest argument is the judge thought the judge did not have discretion, and you would be entitled to a new sentencing hearing if that's correct.
Well, Judge, I did make that. I kind of made two arguments in my 3850. One is that the court was unaware of its discretion, and two, he had no discretion whatsoever. But the judge imposed consecutive sentences on the armed robberies, two qualifying offenses.
Right.
This was one criminal episode. So therefore, he was prohibited from imposing consecutive sentences. And I referred to the James case from this court, where even in less compelling
What
circumstances.
did the judge do on the kidnapping charge? You got one kidnapping NG and one guilty.
Yes, the kidnapping charge he ran concurrent to the robbery charge from the same victim.
Okay, I get you.
So the two robberies were consecutive, and then counts 3 and 4 with the second victim were concurrent. So my argument is one criminal episode. The James case supports my argument because in that case, it was even under less compelling facts. There was robberies a day before. The police went looking for Mr. James. The day after, he shot at them. And although the court doesn't say it, it's obvious that the court found that it was one criminal episode because otherwise the court would not have had discretion. So in the James case, it was less compelling. In our case, where there's one phone, two
Help me out, because I recall vaguely the James case, but help me out. Where are you drawing this legal rule from, the facts that are reported in that case and the legal ruling that was issued?
Okay. In the James
And
case.
the arguments that were made that were before the court, because that's kind of important too.
Okay. In the James case, and I'm reading from James, it says, at the time of the offense, officers were attempting to arrest James for multiple robberies that had taken place the day before. During one of the robberies, the gun used in the instant offense was stolen. So they stole one of the guns from the robberies, used it when the officers tried to apprehend him. And then at sentencing, the defense counsel obviously made an argument that this was one criminal episode, and the court actually had this discretion because the judge even says, and there's a quote, that's a creative argument, and credit to defense counsel for coming up that it's part of one criminal sequence. I think it was separated by a day, right? If I'm remembering correctly. Then this court doesn't say that it's one criminal episode.
Did anybody argue it though?
Yes.
Was that an issue on appeal?
Yes. And I just filed a motion to ask this court to take judicial notice of the James case. I filed the appellate briefs. There was only 2. There was no reply brief with this court on Monday.
Well, okay, because the way it works, Mr. Foreman, is that you read an opinion and we're bound by the opinion, but we're we're supposed to focus on just what's in the opinion and not pull out what all the briefs were and all the arguments were, because that's what the lawyers rely upon. So it's a little bit, you don't get to go behind the curtain once the opinion's issued. That's why I asked that question.
No, I understand, Judge. I did cite multiple cases from this jurisdiction that says a court could take judicial notice of its own records, and that was the basis of my request.
I understand the basis of your request. I'm trying to get into the basis of your interpretation.
Okay, fair enough,
Of an
Judge.
opinion.
If you look at the James opinion, even on the four corners, it's certainly missing the language that I wish it had, of course, but there's no
Right.
other logical conclusion of the result unless it found what I'm suggesting, Your Honor.
Okay.
So, respectfully, I'm asking that either the court find that the judge had no discretion or had discretion and was under a misapprehension. Now, as far as the other arguments raised, because I did raise numerous arguments, obviously some have more merit than others, but I want to talk about the issues that were summarily denied. The court repeatedly throughout its order said that there was substantial evidence in this case. That's why those claims were summarily denied. But prejudice could be established in two ways. One, the but-for test, but for defense counsel's acts and omissions, the outcome would have been different. Or if the trial was rendered fundamentally unfair. I mean, that Strickland, the language is all over Strickland. The Florida Supreme Court has that standard as well.
Which one are you going by?
The fundamentally unfair one, Judge.
Okay, so
Because-
you're kind of conceding the prejudice. There's no prejudice? I mean.
No, I'm arguing there is
upon
prejudice.
Substantial evidence?
I'm arguing that there is prejudice, Judge, but I'm saying
Oh,
that
no, I mean the substantial prejudice aspect.
I'm not conceding either one, but I would suggest that I'm just giving the court an alternative.
I just meant to say substantial evidence. There's all kinds of evidence of guilt here.
Judge, there is, but he testified at trial. He explained why his cell phone, he had a story where basically.
The stranger, he just loaned his vehicle to the stranger, had all the phones, 2,000 cash, and he went off to a park to meet a prostitute.
Correct, Judge. Obviously, it's an interesting story, but his credibility was key, Judge. He testified, and the acts and omissions of counsel allowed all sorts of evidence out. Basically, even if there was going to be some credibility to the story, basically it was blown out of the water by what happened with counsel's conduct, opening a door about the Fifth Amendment, allowing the state to talk about, hey, this is the first time you've ever raised this story ever. You didn't tell the cops that. You refused to give DNA. Hey, if the jury, in his comments in closing, if he'll lie to his wife and he tells the jury, what do you think he'll do to you? What do you think he thinks of you? That's what he says.
But didn't Pinkston embark on a monologue when his client asked him how much later, and he went into a lot of detail himself to try to prove his case?
He did, but my argument is you shouldn't have even broached that subject. Once you did that, there's always that potential that your client's going to exceed the scope of the question. But once you start asking your question, did you speak to law enforcement?
But Mr. Foreman, I hear what you're saying, that there's some Fifth Amendment stuff that gets kind of tripwired in this that's maybe a little concerning. But I mean, isn't that part of the strategy decision when you counsel a client whether or not to take the stand in a criminal proceeding? That look, the questioning might go some different ways, and the client may not hold up very well, may say some things that are regrettable. I mean, why doesn't that go to just look? That's baked into the strategy component of the test, that this was a strategic decision to have Mr. Pinkston take the stand and kind of roll the dice a little bit, and they didn't come up good for him.
Well, there was no evidentiary hearing on the claim. And if it's a strategic decision, normally it's resolved via an evidentiary hearing. So we don't know what sort of preparation. We don't know if he said, hey, listen, just limit it to a certain area. Here's what I want to do. So it was just summarily denied. So we don't know. Mm-hmm. And obviously, if your honors look at the drawing, it's a composite sketch that was made. And my client, they look totally different. And that goes into my other claim about failing to call an expert. Both of these witnesses, obviously, is a traumatic event. The first witness or the first victim had multiple difficulties identifying my client, even in a video, even in a photo lineup. And then suddenly when one of the officers says, hey, we're not going to press charges in your case, then suddenly she says, oh, he looks now basically seeing how he walks when he's handcuffed behind his back. I think that's him. So there was issues with identification. There was also issues with identification with the second victim. With the photo lineup, one of the fillers or my client's picture was a little bit different than the fillers. This expert is a professor in psychology. He would have explained about the different issues with recall, suggestibility, all sorts of different things that would have played on the misidentification rather of my client. So it wasn't just one error in and of itself. It was the multiple errors, all of them summarily denied, all of them required an evidentiary hearing. Even if there's substantial evidence, there was still conflicting evidence. And my client presented testimony. Of course, his credibility was at issue. These acts and omissions of counsel affected directly his credibility, even providing a motive by telling the jury that he had a credit of $50,000, the exact amount that was asked by the perpetrator from the first victim. So it's just the multitude of errors in this case basically deprived Mr. Pinkston of a fundamentally fair trial. That's where the prejudice lies. It wasn't a clear-cut case. It was circumstantial. And again, he testified. He didn't even have any priors, anything along those lines.
You're getting up to your 5. You want to keep going or you want to?
No, sir, I've said enough. I'll reserve for my rebuttal. Thank you.
All right, you're welcome. Mr. Hellickson?
Good morning, Your Honor. And may it please the court, if the court has any questions about the summary denied claims, I can obviously address this first, or if you want me to go to.
The biggest question is going to be the sentencing.
Sure.
Did the court
absolutely.
have discretion? Did the court believe it didn't have discretion? So was there discretion to give consecutive sentences? Was the court required to give consecutive sentences? Was the court prohibited from giving consecutive sentences? Where do you come down on that?
And that's an interesting question, Your Honor, and it gets a little bit tricky with the interplay of the 3.800A motion, because obviously if you're under 3.800A, the sentence has to be legal. And so there is, I think with the post-conviction court, with its explanation, and obviously that claim was denied after the state responded. I think it's a little bit, confusing with that case. So if you look at Williams, which would have just come out around the time that this case was decided, they kind of took an interesting take on the way that the mandatory minimums and the consecutive versus concurrent sentencing plays out. So what the Williams case essentially said was that if you have under the 1020 life statute, the 775-087 sub 2D part of it, they said basically they kind of said that they read that the qualifying offenses could be imposed concurrently with each other, but if you had a non-qualifying felony, the sentence must be imposed consecutively. So that's an interesting.
You've got 2 qualifying offenses.
Correct, Your Honor. That's how
consecutive on 2 qualifying offenses. But does the judge believe the judge had the discretion to give concurrent on those 2 qualifying offenses?
That is really unclear, Your Honor. If you when you look at the sentencing, hearing, I don't know that the court is necessarily clear that it did have the discretion. Again, Williams would have just come out around this time, so there could be a little bit of, interplay with how that case
related. The state attorney, tell me if I'm reading the transcript wrong, the state attorney at sentencing argued, what I think I hear you saying is the court is obligated to alternatively impose 20 years consecutive. And the state attorney said, yes, 10 plus 10, back to back. So where's the discretionary concept in that?
And I think that's part of the, the issue, Your Honor. I think that in the post-conviction order, I think it kind of alludes to the fact that maybe it didn't have the discretion there, but I don't know.
So, I mean, are you sticking to your argument in the brief that the court didn't have discretion, or the court did have discretion and messed up? What do we got here?
And it's really confusing with the way that the case played out, and with how this case played out, and then the the way that the post-conviction order was written, and then I think some of the discussion at sentencing, because this area that you're dealing with it's very confusing. And so the way that that you look at the sentencing, and I think that I honestly, I'm not 100% sure what the trial judge, found in this case, because if you look at, the sentencing and you look at the post-conviction order, it does seem to allude that, it had to impose the sentences. And, I'm not sure if it necessarily believed it had to impose a consecutive sentence, or if it believed it could impose, because obviously it ran the kidnapping and the armed robbery concurrently, and that it imposed the two sentences against the two victims consecutively. And that, is technically, it's a permissible way to structure the sentence. Like Your Honor said, it just goes to the question
It
of.
doesn't make it illegal. It means the court could have done concurrent on the two qualifying offenses, but if the court believed it didn't have the option, then normally we send it back and let the judge consider what you really want to do. Make your factual findings, tell us why you did what you did, as opposed to saying, I did it because I had no choice. That's the problem I'm having with that issue. And I don't know if you want to, address that any further, but you don't have to. If you want to go on to his other issues, he didn't talk about the sleeping juror, so I assume that's not going to go anywhere. You want to talk about any other issue?
Well, I just wanted to make one other comment for that point, Your Honor. When this court has reversed, it's usually been on direct appeal. I don't know if it's done so in the 3800A category in context. If you look at, and I did want to make one distinction, that the post-conviction court did distinguish its case from the James case of this court, and James, the state did concede error, and the post-conviction court said that it is not reading the facts of James. It's not able. It said that this court could have essentially decided James on an issue that wasn't, presented in the opinion. Essentially, is it saying that it wasn't going to read this court's decision in James as implicitly expanding Williams to encompass two separate victims? And that's the only thing I wanted to point out, is that traditionally when this court has remanded, it's been on direct appeal, and then I'd be happy to move on to the other claims, Your Honor.
You got your time.
If the court doesn't have any other questions on that issue, I'll briefly address the other ones.
Sure.
And so if you look at the context of the trial, Mr. Pinkston received exactly what he's supposed to under the Sixth Amendment. He received a fair trial with competent counsel. There were numerous issues brought up during pretrial. So they did a motion to suppress on the identity on the out-of-court statements. The trial court said the state or the police did not use an unnecessarily suggested procedure in obtaining the identifications, and it was not going to determine that the out-of-court statements or the out-of-court identification was so prejudicial that it was going to transfer that to any in-court identification. Because what counsel was trying to argue is that you have this out-of-court identification that's so prejudicial, so unnecessarily suggestive, that it would taint any in-court identification. And so the trial court, ruling on the motion to suppress, said no, the police did not use an unnecessarily suggestive procedure, and then did not prohibit them from, if they could, identifying Mr. Pinkston in court. And then if you look at Miranda and then also the DNA claim, so counsel was presented, if you look at their closing argument, what they were trying to show is that the police conducted a rushed investigation. And so they wanted to show that the police had this DNA sample, but did not have it tested. And the only way to get there is to show that Mr. Pinkston had been transported down to the jail. And so the fine line that they were walking is to show that he was arrested, transported to the jail, and then while at the jail, his DNA was swabbed, and the police had it and just didn't bother to get it tested.
Well, it was a matter of refusal of the buccal swab. The officer said that Pinkston refused, and Pinkston says, "Oh yeah, I agreed to it, and they just didn't take it. They had it available." Isn't that the argument essentially about the DNA?
A little bit, Your Honor. So one of the detectives testifies because at the police station, Mr. Pinkston invoked his right to an attorney. And so the officer's testimony is, well, we couldn't get DNA at that time because he refused. So then they need to get into this, they go down to the jail. And so at the jail, that's where Mr. Pinkston testifies. I was taken to the jail, and while at the jail, they swabbed me for DNA. And Mr. Perlman, the defense attorney, says, well, did you refuse, or at some point did you refuse? And Mr. Pinkston's kind of surprised by the answer. He goes, yeah, I was surprised by that because I didn't refuse anything. And so that's where that play comes in. But they wanted to show that the DNA had in fact been taken from Mr. Pinkston at some point in time subsequent to his arrest, and the police had just never tested it. And so you have that fine line of, he's arrested, transported to the jail. And I don't think that with counsel's questions that they anticipated that Mr. Pinkston is going to say, well, in the back of the patrol car, I expected the officers to read me Miranda, but they didn't. And I thought they were supposed to. I don't think that would necessarily flow from counsel's arrest question, because if you look at the context, they ask him about his arrest and he goes, oh, those officers were good. They got me in handcuffs, they got me on the ground, and they put me in the back of the patrol car. And he goes, as I'm in the back of the patrol car, I'm thinking they're going to read me Miranda. He goes, but they don't, which I guess they don't have to do. I was kind of confused by that, because if you look at the entire trial, you'll see that Mr. Pinkston, his background was actually, he was like a second in command of a law enforcement battalion in the military. So he kind of knew the law enforcement procedures here. And so they have to kind of go from there to him going to the police station. And so they say, well, at some point in time, do they begin to ask you questions? And Mr. Pinkston says, yes, later. And he goes, well, how much later? And then Mr. Pinkston gets into this explanation of how they drove him to the police department, how they put him in this room. He met with detectives. They were really polite. They read him Miranda, and he said, I want an attorney. And then they said, well, did they ask you any other questions after that? And he said, nope, they did exactly what they were supposed to do. They stopped talking. So based on those two, and those two Miranda issues, then the state was able to elicit a little bit more. But I would point out to the court that in most of the cases where the reversals have come on the Miranda issues, so there's 2 points there, Your Honor. One is this incident wasn't highlighted at all during the rest of the trial. You had just those 2 snippets of it during direct examination and then the state's cross-examination. So this wasn't an instance where it was highlighted multiple times during the trial. I believe the state was going to go down that road during closing, and the record's not exactly clear because the post-conviction court's order says that the defense counsel objected and he had a bench conference. But the record shows that it might have been the trial court that said, oh, can you please approach? But either way, they had a bench conference, and the trial judge says to the attorneys, you don't get to walk down that road unless you can show me that he opened the door on cross-examination. And assistant state attorney says, well, I believe he did. And the trial court was very clear, because at this time, Mr. Perlman had argued that the state was shifting the burden by getting into that pre-Miranda or post-Miranda silence. And so he said the state's shifting the burden. The trial court absolutely agreed and said, state, you don't get to walk down that road unless you're absolutely sure. The state couldn't prove to the trial court they were absolutely sure. So that he didn't let the state go down that road for it to become a feature of the trial. So it was just those 2 snippets of direct and cross-examination that you have. And if the courts that look at it on direct appeal would look at it for harmless error. And then obviously we're in post-conviction, so you look at it under the 2 prongs of Strickland, which would be first, was counsel deficient in asking the questions? And then 2, did that substantially prejudice the trial such that you can say he received an unfair trial under the 6th Amendment? And I don't think I believe that, counsel was acting, competently during the entire trial. They made the objections, they presented the argument. As far as the $50,000 credit dollar line, there was testimony that Pinkston's business brought in lots of money. And then there was also testimony from him that he paid $50,000 to get out of jail. So there was no
positive for the defendant. Isn't that positive for the defendant, that information?
Yes, Your Honor.
You're arguing it's a negative, but I don't see where it would be negative if it's unrefuted that he had access to all kinds of money and he was up to date on his payments and making payments on the credit line.
Right. I just wanted to bring up the fact of that $50,000 credit line, that there was other testimony about that amount of money and Mr. Pinkston would have been able to afford it. So it wasn't just that credit line that came out on the $50,000.
Okay.
And so if your honors, I think I'm running close to the time or either over it, but
No, you're okay. You've got a few minutes left. You can stop though. There's no reason to use it all if you don't want to. I'm not compelled.
Yeah,
to keep going.
I was going to ask your honors if you had any other questions, and if you don't, I'd ask the court to affirm.
Any other questions? Any other questions? All right, you got it. We'll switch to Mr. Foreman. Thank you, sir.
Thank you, your honors.
Thank you, Your Honor.
All right, Mr. You got 5.
Thank you.
I'll give you 5.5. So I think I cut you short by 30 seconds.
That's okay, Judge. It's no problem. I do want to point out, as far as the sentencing issue, he's charged with armed kidnapping and robbery with a firearm. They're all qualifying offenses. So I don't know how the judge can impose consecutive sentences at all if it's one criminal episode.
Well,
And
that's the test. The question is it one criminal episode for
Correct.
sentencing purposes? And that could go either way. The judge obviously had the discretion to find certain facts to make it 2 criminal episodes because there was separation in time. They had different victims. This factors going every which way. And then that's different from the severance analysis, which you didn't make that argument, but I assume you're sticking with the sentencing argument.
Correct, Judge.
So you're saying we reverse this and we personally say the sentence is 10 years across the board.
What I'm saying is, first of all, I don't think it's an abuse of discretion standard. I think it's a de novo standard. I raised it in a 3800A. That's a de novo standard. It's a matter of law. And if we're talking about how close it is here, should the rule of lenity, should it favor the defendant if it's such a tight rope that we're walking? But so it's a matter of law. I don't think it's an abuse of discretion standard. That's why I filed the 3800A. And if I'm right, if it's one criminal episode, it is. And
So
again,
you're saying armed kidnapping is a qualifying offense. It's
that's
not-
what I'm saying.
Not
Yes.
any other felony. And are you agreeing that if all of these are qualifying offenses, the court nevertheless would have had discretion to impose these consecutive? But if the court believes it didn't have discretion, then we'll never know why the court did what it did.
Well, the court clearly didn't believe it had discretion. But of course, the $1 million question is, was this one criminal episode for either analysis?
Totally agree.
And of course, I'm, shooting for the fences and saying that the court should have never imposed or could not have imposed consecutive sentences. Now, as far as some of the comments regarding the Miranda, and I'm going to touch on the sleeping juror issue regarding the Miranda and the DNA, that was actually brought up in closing by the prosecutor on page 2131 of the record, so much that the judge even said, wait a minute, where are you going with this? The judge actually stopped the prosecutor, and then the prosecutor did it again with the DNA on previously on page 207677 of the record. So, I mean, Miranda is such an egregious violation. To bring it up, open the door, and then talk about not only that the fact that he didn't speak to the police, but he didn't tell them his version. It's commenting on silence. That's clearly error. Defense counsel didn't object to that. I mean, these are pretty egregious errors that we have here, especially in combination with the fact that they didn't call this expert who would have shed light and explained to the jury all the different issues with the misidentification. Because remember, his picture was seen, or his video of him purchasing the phone from Walmart was shown in the news prior to any identification being made. The expert would have talked about all this stuff. This was a very critical issue. I mean, look at the composite sketch. They're totally far-fetched. One looks like a guy from a movie, a TV show, and the other one is my client. So cumulatively, all these different mistakes deprived him of this fair trial. Now, as far as the sleeping juror, obviously I understand.
Before you get into that, I'll give you some latitude, but I don't think he talked about sleeping juror. And you're in rebuttal. So what are you going to rebut about the sleeping juror?
Well, I'm not going to rebut about the sleeping juror.
I'll give you latitude. Go.
Okay, thank you. I understand that both lawyers testified at the evidentiary hearing that the juror wasn't sleeping. But if you look at the totality of everything, the judge's comments, when the lawyer said that they paid attention to him on the record, then at least, like I argued in the lower court, there's certainly a doubt as to whether he was sleeping. And And,
But they
and due
both wanted
process,
both sides wanted that particular juror, correct?
excuse me, I'm sorry.
Both sides wanted that particular juror, true or false?
That is true, but due process requires a certainty that your jurors are not asleep. And obviously it's a due process violation.
There has to be a reasonable basis to believe that. All the evidence shows the guy was taking notes. He would close his eyes. He's obviously cogitating something. Wait, he'd go upright and start taking notes. And he didn't take as many notes as everybody else, but he was still taking notes. Everybody was satisfied. The guy's not really sleeping. He's he's engaged.
Well, that was a testimony at the
First
evidentiary.
thing.
I
Okay,
understand that at the evidentiary hearing, that was a testimony, but if you look at the totality, I would suggest otherwise, but I understand the court's position.
fair enough. You got 20 seconds. You want to wrap it up? Or you want
Yeah, I
to-
think I can wrap it up. I'm just respectfully asking the court to find that consecutive sentence could not be imposed under the facts of this case under de novo standard. And that also that he was deprived of, or at least we required an evidentiary hearing for the remaining claims that were summarily denied.
All right.
Thank you, Your Honor.
Perfect timing. I want to thank both sides. You both were brilliant. I appreciate it. We're going to let you go about your business, and we're going to start the next case, which is the Hopheads versus Thomas.
Thank you, Your Honor.
Thank you, gentlemen. All right. We have both players here.
Yes, Your Honor. Yes, Your
All
Honor.
right, let's proceed.
Thank you. May it please the court, Heather DeGrave on behalf of the appellant Hopheads, and I'd like to reserve 5 minutes for rebuttal.
You got it.
The final judgments in this case should be reversed because they were entered in disregard of two fundamental principles of civil litigation. One, that the issues that are tried at trial should be only those issues that are actually framed by the pleadings. And two, that damages are determined as of the commencement of the case. In this case, the only two ways that appellee may be entitled to judgment for the full principle of the note at issue was one, because the note has matured and the borrower has failed to pay the balance in full without valid excuse, or two, appellee had properly accelerated the note. It's clear from several statements by the trial court during closing argument at trial and in the findings of fact and conclusions of law that the court considered the fact that by the trial date, the maturity date had passed, and the judge considered that to be relevant to the entry of final judgment. However, and in addition, Mr. Caliu testified that the full amount was due, not because there had been an acceleration of the note. In fact, he testified that there had not been an acceleration of the note, but because the note had matured by the trial date. But the problem is that at the time of the commencement of the case, and even at the time of the filing of the second amended complaint in the action, neither the original note nor the extended note had reached a maturity date. So it wasn't included in the pleadings, and final judgment in the case below should not have issued based on the maturity date.
But Ms. DeGrave, in the second amended complaint, I think it's in paragraph 16, it alleges that the borrower defaulted under the loan documents by failing to make the monthly payments due in December of 2014 and other payments thereafter. How does that not solve the problem that you're complaining about?
Well, two things, because at the time of the filing of the complaint, at the time of the filing of the second amended complaint, the maturity date had not yet come. So
okay, but that would, if what you're arguing is then somebody could never bring an action on the default of the note unless the maturity date had passed, as opposed to a default, which is what was brought here.
Right. No, I'm not saying that.
Okay.
I'm saying that, what the case law is that is that when you have a note that includes installment payments, that each failure to miss is itself a breach that could give rise to a cause of action. But unless there's an acceleration of the note or you've reached the maturity date, the full balance of the note is not yet due. All that's due is the missed payments. That would be all that's due. So at the time of the commencement of the case, unless there's been an acceleration of the note, the full value of the note was not yet due. And so
But
it was
even
not
under
included in
even
the
under the lights of your argument, Mr. Grave, because the kind of the touchstone of the lack of notice and pleading is whether or not your client is in any way prejudiced. How can they possibly claim any kind of prejudice when they're already subject to an existing lawsuit and are presumably aware of the terms of the note and were aware that it had reached maturity? I mean, it's hard for me to imagine how they can credibly claim in good faith to have been caught unaware that, oh goodness, we are indeed going to argue the issue that this note which maturity date has passed has come mature and that they're seeking the full damages under either theory, whether it's acceleration or maturity.
Right. Well, and the thing is twofold. First of all, the defendants may have had a number of defenses why the balance wasn't paid at maturity, and one of those could have been the actual pendency of this proceeding. So if you have the foreclosure proceeding pending with a lis pendens pending, that may impair, if to the extent that the defendants wanted to use the property as leverage to obtain the funds needed to pay the balloon payment, they would have been impaired in their ability to do so by the pendency of this foreclosure proceeding for the full amount, even though the loan had not been accelerated.
What does that have to do with prejudice and vis-a-vis the litigation itself? Because that's what your argument is, that this was a pleading deficiency, and so the prejudice has to be measured in terms of how your clients litigated and were caught unawares as a result of this purported pleading deficiency. That's what I'm trying to drill in on. That in every foreclosure case, every default case, there's always going to be ancillary matters about, well, if the bank just wouldn't foreclose, I could do this, and that. But I'm trying to keep this focused on your argument, which is a purported pleading deficiency.
Right. So if you look at the trial transcript, you can see that counsel for the defendants, Mr. Meacham, was preparing the defense of waiver and estoppel with respect to the acceleration of the note. And he's starting to question Mr. Callio with respect to the acceleration of the note so that he can attack that. And then Mr. Callio says, no, there was no acceleration of the note. The reason why the full amount is now due is because we've reached the maturity date. So here we are at trial for the first time learning that now the reason why they're saying that,
and that kind of goes back to what I said at the beginning. I mean, the note is attached to the pleading, right? Everybody can read the maturity date. And that's why I'm having a hard time accepting this argument, is that it's really hard for me to understand how anyone can claim to be prejudiced that the argument is being made, hey, we're due the entire note because the maturity date has come and gone in the course of this litigation, when the note was front and center there and they're already in litigation about default on the note.
Well, the thing is that if the plaintiff had either amended its pleading before trial, shortly before trial, or had what would have actually been more appropriate under the rules, is done a supplemental pleading, which said that this maturity date accrued while it was pending, and had the supplemental pleading, then the defendants would have had the opportunity to file and pursue their defenses, including, hey, we were going to use this property as our leverage to obtain the funds necessary to make that balloon payment, but we couldn't do that because it was subject to this lis pendens. So no, it was subject to this lis pendens for
how would that have even been a cognizable defense to the maturity date default?
Because if the lis pendens is impaired, then no lender who might otherwise.
I understand how LPs work. I'm just trying to figure out your argument that they sued us. There's an LP out there. we were going to use the property to pay off the note. Okay, great. But what does that have to do with the fact that the note's mature now and you haven't paid it?
That's what I'm getting at, is that
But that's not a
while
defense.
it matured while the improper foreclosure proceeding, because the foreclosure proceeding was improper.
Okay, so
The
this
note had not been
basically all of
accelerated.
this flows from your notion that this is the whole proceeding shouldn't have been brought.
Yeah, because
Okay.
because the note had not been accelerated, that's what Mr. Callaway testified to, yet they demanded the full balance. Not only did they demand the full balance, they actually demanded $379,000 in the complaint. That's what they said was due, even though it was impossible that the principal amount was 379 at the time that was had sold, because the maximum principal of the note was 300,000. So you have a lis pendens and a complaint that's saying that this property is encumbered by this $379,000 obligation.
Did you all
That is going
challenge the
to
LP at
deter.
any time? Did you seek to dissolve it?
Well, it's not that we sought to it's not that the defendant sought to dissolve it. The point being that the fact that the date note matured during this proceeding, one of the defenses among others, and I'm not trial counsel, so I wasn't privy to, there may be other defenses that the defendants knew about and would have raised with respect to why we didn't pay the balloon payment on maturity. But one that I can foresee is that this foreclosure proceeding was pending, and so they couldn't obtain in an improper amount, and so they couldn't obtain the funds that they needed to make the balloon payment. But the point being is that because the idea of the maturity being a basis for the full value of the note was not pleaded, and so my clients were not able to meet that pleading with a defense. What was pleaded was that the note had been accelerated, and as you see in Mr. Meacham's questioning of Mr. Callaway, he was preparing to meet that claim. He was preparing to meet that claim with it. A, it wasn't accelerated, and B, there were
Mr. Meacham
equitable
request a
reasons why.
continuance?
No, Mr. Meacham did not request a continuance, but Mr. Meacham did argue in closing that the issues are framed by the pleadings, and so that the judgment can only be based on the pleadings as asserted. So he did reserve that argument at trial. In addition, and so by basing the judgment on an issue that was not pleaded, it deprived defendants of a meaningful opportunity to respond with its defenses. In addition, as I mentioned, the evidence at trial was that the note itself had not been accelerated. So the full value wasn't, the evidence at trial was that the full value wasn't due based on an acceleration of the note. The acceleration provision in the note is optional. It's optional so which means under Florida law that it's not automatic, it's not self-executing. The plaintiff has to take an affirmative act to trigger it. And what Mr. Callaway testified to is, no, we had not triggered it. And this idea that without notice, it doesn't mean that we can just somewhere in the back of our mind believe that we've accelerated the note. What it means is that they don't have to provide any notice and opportunity to cure before they accelerate, but they do have to give notice that they've actually accelerated, and they didn't do that. So none of the documents offered in evidence contain any language where the plaintiff exercised its option. And also they conceded that no acceleration had occurred. So the final judgment should not have included the full accelerated balance, but only those amounts that had actually accrued as of the commencement of the case. And the trial court also should not have included default interest at the default interest rate, because if you look at the provisions of the default interest rate under the note, the default interest is only triggered if the note is accelerated. It's very clear. It says, it talks about the acceleration provision, the final principal, the full principal and all interest and fees become immediately due and payable, and default interest will accrue on that sum at the maximum legal rate. So it's only triggered if acceleration is triggered, and plaintiffs conceded that acceleration wasn't triggered. So the judgment should not have included interest at the default interest rate. In addition, the note is silent on the issue of the application of the payments to past due balances. And this gets into the back and forth between the emails that you saw Ms. Gibson send Hopheads and Mr. Ortiz regarding the monthly payments. You saw she would send in March, the March payment is due, pay the March payment. And then you would look at the payment history, and in fact, they made a payment in March. Then in April, you see the April payments due. And then you look at the payment history, and in fact, they made a payment in April. And so what you see is what is actually being said to defendants is this is the payment that's due. This is the payment that's due. What's not being said is, by the way, we're holding this back we're going to apply it to past due payments. We're holding, and so you still actually owe the March payment because we applied what you sent in March to past due payments. They didn't say that. So there's the equitable principles are that you shouldn't accelerate based on a default when you've said make the payment and they make the payment that you told them to make. So there was no notice that payments would be applied to past due balances, and under these circumstances, it can only be assumed that the payments were applied to the current payments that were due. The defendants were lulled into believing that the payments were being received, that they were not considered in default, and so the plaintiff should have been stopped from claiming late fees and default interest on each payment based on its internal application of payments when it did not give the defendants any sufficient notice of payments. The defendants tendered payments, and for whatever reason, they were, well, not for whatever reason, because they apparently weren't by cashier's check, which was not required by any provision of the loan documents, they were refused. So equitable considerations prevented the enforcement of some undisclosed decision to accelerate or deem them in default. And finally, with respect to the subordination agreement for Tampa Hyde Park Cafe, the subordination agreement.
You're at your 5 minutes, but if you want to keep going, be my guest.
Okay, I'll wrap this up very quickly. The subordination agreement refers only to the mortgage of March 2014, while the leasehold subordination agreements refer to any and all mortgages. The two assignments of rent were updated and re-signed when the extended note and mortgage were signed, but the subordination agreement was not. The guarantees of Mr. Mustard and Mr. Ortiz were given as replacement for the subordination agreement upon the modification. Mr. Ortiz testified to that. And Mr. Ortiz testified that Tampa Hyde Park Cafe refused to subordinate the higher loan amount. So the evidence is that Tampa Hyde Park Cafe did not agree that its easement agreement was subordinated to the modified mortgage. It only agreed that it was subordinated to the original note and mortgage. And the case law is that intervening liens, even if they are subordinated to an original mortgage, they are not subordinate to later recorded mortgages. So the foreclosure judgment should only apply to the extent of the original mortgage, not the mixed modified one. So the judgment was entered based on facts that had not occurred as of the commencement of the case. Plaintiff never exercised the option to accelerate the note. And so we request that the court reverse the judgment of the trial court. Thank you.
All right, that leaves you 3.5 for rebuttal.
Thank you.
Ms. Ahmed?
Yes, Your Honor. May it please the court, my name is Farha Ahmed and I represent Appellee Allstate Funding Corporation. Your Honor, I'd just like to sort of simplify the facts for you a little bit about what this case is about. The plaintiff, the appellee here, is a hard money lender, short-term private lender. This is a commercial loan and we're dealing with a property that's a parking lot. Here you have two sophisticated parties that have done business together on multiple occasions prior to this, and they entered into a commercial contract. On March 12, 2014, you have a note and mortgage executed, principal amount $129,500. Then Same day, you have a subordination and easement termination agreement entered into between borrower and Tampa Hyde Park. There was an easement agreement, and then it said that the easement is subordinate to the mortgage, and that entry of final judgment on the mortgage would terminate the easement. There was also lease subordination agreements, 2 lease subordination agreements entered that day, stated that those leasehold interests are subordinate to the mortgage, and that entry of final judgment would terminate those leases. And then September 8, 2014, an extension and modification agreement was entered into, which
Can you go to the question or the argument that was raised by Mr. Grave about the acceleration issue, where Mr. Kalu doesn't testify that the note wasn't accelerated and therefore this is outside the scope of the pleadings?
Okay, Your Honor, one, the court does, if we could step back a little about, what the trial court decided and what the standard of review here is. Mr. Grave or appellant would have you believe that this is some sort of de novo standard here, but this is an abuse of discretion standard. And so what we're looking at here, we're not here to relitigate the facts and what the trial court determined. The trial court doesn't, or the appellate court here is not here to reweigh the evidence or the credibility of the witnesses. You don't look at whether there's possible contradictory evidence to, that supports arguments that were rejected below. We're not here to retry or substitute the judgment of the trial court on factual matters that are supported by competent substantial evidence. So given that, the court here decided that there were multiple defaults and multiple notices that were sent. At the very least, there was that August 12, 2017 payment, or there was a notice sent.
The notice to cure.
On August 2nd, 2017 that said make payment by August 12, 2017, and they failed to make that payment. And so at the very least, there was that default. The trial court did not rely on the note maturing in making their final judgment. That is just a fact that the note matured on the eve of trial. And that was just simply a fact that was noted by appellee, and that was noted by the trial court, is that the note matured. And so there was no reliance on that. And so, the idea that the court relied on that, there's nothing in the finding the fact and conclusions of law.
Let me ask it this way: if there was no acceleration, then did the lender have the right to bring a foreclosure action?
Yes, of course, Your Honor. Any default of the note allows a lender to bring a foreclosure action.
And so does whether or not Mr. Kalu testified that they didn't accelerate the note is of no matter. Is that's what I'm trying to understand, what your position is on that.
Your Honor, Mr. Caillou isn't an attorney and doesn't even probably understand the legal, what the legal effect of acceleration is and what the meaning is. All he knew is that there was missed payments. And that's what he testified to, is that there were missed payments. Whether or not he knew the technical term of what an acceleration, what it means to accelerate or not, that his testimony cannot be taken to determine whether or not acceleration happened. The fact is that this is a commercial note with very basic terms, and this is, unlike a residential mortgage, a commercial note is, and this is very sort of bare bones note. Mr. Grave keeps talking about lack of notice. This note specifically says that no notice is required. There's no notice required to accelerate. There's no notice required to charge default interest. There's no notice required, there's no notice required to say, we're going to, no demand letters required actually in this note. It's, and so again, there's just no notice required. And so this idea that you can only accelerate if you provided notice, actually the note specifically says, and I'll read it to you, is sorry. Honor, I'm trying to find the entire principal sum and accrued interest shall at the option of the holder become at once due and collectible without notice. And so it says that simply, without notice. And so it really is sort of by operation of law whether or not acceleration has taken place. The fact is that appellee had been charging default interest, and appellant had been paying default interest since February of 2016. I'm sorry, Your Honor. And actually, Your Honor, I'm a little surprised that now the argument seems to have changed a little at oral argument here, because the entire brief was focused on this lack of thoughtful and independent analysis of the trial court. And again, you know, appellants argued that there was some de novo standard, and clearly, you know, in Musgrave versus Musgrave, the Second District Court of Appeals stated that, you know, when you're looking at whether thoughtful and independent analysis was done by a trial court, that's an abuse of discretion standard. And so the entire brief was framed around this idea that that thoughtful and independent analysis wasn't done by the trial court judge, because they used proposed findings of fact and conclusions of law. They used the appellee's proposed findings of fact and conclusions of law as a template. And so the argument, in a roundabout way, the appellant was trying to make this argument that, you know, trying to get you to look at all of the findings of fact and make different conclusions, different findings by, you know, looking at each one of these facts and saying, look, because they decided this way, they should have decided this way. And it shows that the judge didn't do independent and thoughtful analysis, because, you know, they decided this way on this fact, on, you know, on the default issue, on the modification issue, on the estoppel waiver issue, when they when she should have decided this way. And therefore, you know, the judge didn't do independent and thoughtful analysis. That was the entire argument made in the brief. And now all of a sudden there's no discussion of this.
Ms. Ahmed, can you walk me through how interest was because that we do have a finding from the trial court in the uniform foreclosure judgment. How did we get an 18% interest rate being charged?
That was, I believe, Your Honor, if I could get to it really quickly. And I can find the actual like calculation for you, Your Honor.
Well, again, let me ask a better question.
Okay.
Start over. Where in the note will I find, or the mortgage, will I find an 18% rate charge? Because it seemed like 12.99, I think, was the ordinary
Right.
interest. So how did we get an 18% there? Where in the note gives
that was the default interest rate, which says at the highest rate allowable under the laws of the state of Florida. And so at that point was 18%. And so
right. So point me to the provision in the note that ties that.
It says accrued interest shall bear interest from the time from such time until paid at the highest rate allowable under the laws of the state of Florida.
What are you looking at?
In the note, sorry, Your Honor, in the note, page 1173 of the record.
1170.
Yeah, and then the modified note is I believe
the modified.
That was the original note, and the modified note, I believe, that was the original note, Your Honor. But again, the terms of the original note are, still remain, except for the modified terms.
Okay.
And again, as to that issue of the modification agreement, Your Honor, the terms are clear. It is a extension and modification of the original. It doesn't disappear. The terms of the original note do not disappear. They are only those specific terms in the modification are modified, and the rest of the terms in the original note remain. And that's why the subordination agreement and are still valid. The subordination agreements and the easement and leaseholds terminate upon the entry of final judgment. Your Honor, if you don't have any other questions for the foregoing reasons, Appellee Allstate Funding Corporation respectfully requests that this court affirm the trial court's order entering final judgment in favor of Appellee.
All right. Mr. Grave, Ms. Grave, you've got 3.5 minutes.
I want to circle back to Judge Smith's question of Ms. Ahmed regarding the acceleration and whether if the note is not accelerated, the plaintiff still has the right to bring the foreclosure. And I want to make clear that we're not saying that the plaintiff doesn't have the right of foreclosure if there were missed payments. But the question is, what is the redemption amount? What is going to be the amount of the judgment that the borrower or that anyone with an inferior interest would have to redeem in order to prevent a judicial sale? And so at the time of the commencement of the case, the note hadn't been accelerated, the note hadn't matured, so the full principal of the note should not have been included in the judgment. We are not suggesting that they would not have the right to obtain a foreclosure judgment for the missed payments that they could prove, but we are saying that when you're looking at the redemption rights and what the amount of the final judgment should be, it should not include.
Can I ask you a question? Didn't your opponent say acceleration was automatic without notice?
Right. So the language says that if default of payment, then the entire principal and sum and accrued interest shall, at the option of the holder hereof, become at once due and collectible without notice.
So
that's what it says.
When they filed their complaint and asked for the entire principal, was that an exercise of the option that they legally had?
Well, two things. So first of all, with respect to the question about whether it was automatic, it was not automatic because it's an optional clause, and Florida case law is clear that when there's an optional clause, it's not just an undisclosed. There has to be an exercise of the option and notice to the defendant.
So you're saying the complaint is not sufficient. Following the complaint is not sufficient.
Well, a couple of things. First of all, Your Honor, is that when you look at the language, it doesn't declare that we are exercising our option here. It doesn't declare that. It says all it does is recite the language of the note, but it doesn't actually say we declare that it is accelerated. And then also the judge frequently throughout the trial said the complaint's not in evidence. The complaint's not in evidence. So what was in evidence at the trial was that the note had not been accelerated. And that's important because as I mentioned before, Mr. Meacham was preparing to question Mr. Calliew regarding the acceleration and regarding the fact that there were these emails that said, make the March payment. And then we made a payment in March, and make the April payment. And we paid it, and whether that would be, a waiver and estoppel. But then Mr. Calliew said, no, there was no acceleration. We're claiming the full amount because of
I don't want to interrupt you, but I do want to tell you, you've got 30 seconds left.
Okay. So I want to say that we're not suggesting that there's no right to bring the foreclosure. We're just saying that that it shouldn't be for the full balance. And then with respect to the issue of the thoughtful and independent analysis, when you look at some of the questioning of the judge, it's clear that it wasn't done, that what she just did was rubber stamp a uniform final judgment of foreclosure, didn't really consider the issue about the subordination agreement and whether it was still in place with respect to the extended mortgage, and didn't really consider those issues. She kept asking, why is this relevant?
You just ran out of time.
Thank you, Your Honor. We ask that the court reverse the judgments.
All right. I want to thank both sides. Thank you. We'll move on to the next case, which is the Spine Institute v. Moulton. All right. Can you unmute your mic? You ready, Mr. Williams?
I am, Your Honor. Thank you.
Proceed, please.
I'm the appellee, Your Honor. I think Mr. Richards is the appellant.
Good morning. May it please the court. My name's Daryl Richards. I represent the appellate Joseph Spine, PA. I would like to reserve 5 minutes for rebuttal, Your Honor. Thank you. This case concerns whether a spine practice, a spine surgery practice, Joseph Spine, can enforce by temporary injunction a restrictive covenant against a departing doctor, surgeon, who admittedly violated the restrictive covenants in many ways. There is no dispute from the evidence below, and nor was there any finding that the restrictive covenants did not protect legitimate business interests. They did. One was existing patients. The practice provided Dr. Moulton, who was the appellee, access to an extensive patient base. And he saw patients of Joseph Spine for 2.5 years. Second, Joseph Spine presented evidence, which again was unrebutted, that it spent more than a couple $100,000 a year to market its practice in the Tampa Bay area, to develop that patient base, and also to develop an extensive referral network, which is critical to a spine practice. That's how they get their patients, is through.
You want to focus on what the trial court found?
I do, Your Honor. And
the burden of proof and not carrying.
That's correct.
Three issues.
I will. I'll get to that. So what the court, the errors committed by the court, in our view, are with regard to the presumption of irreparable harm, presumption of an inadequate remedy at law, and a determination regarding the public interest / public health issue. On the presumption, the court made note that there was a presumption, but the court did not apply that presumption. In fact,
time out. Didn't the court say, in view of the presumption, or despite the presumption, that's not enough standing by itself? The facts in this case support that your client didn't carry his burden of proof.
Well, that's correct, Your Honor. And the way the presumption is supposed to work, it's a rebuttable presumption. But once we established the multiple violations, we met our burden because there is a presumption. Then the burden shifted to the other side to present competent legal evidence to rebut that presumption. They did not do that.
Well, let's talk about the adequate remedy at law, that element.
Yes, sir. The adequate remedy at law. I apologize. I thought you were done, Your Honor.
I was just going to say, focus on the adequate remedy at law versus, was this liquidated damages or was it something else?
Yes, sir. I'll be happy to do that. As this court held in the Surgery Center versus Gurgis case, the presumption applies both to the irreparable injury piece and the inadequate remedy at law piece. So we met our burden by showing the violation. So then the burden was supposed to shift to the other side. The only rebuttal that was presented below, and what the court specifically said was, and I'm looking at the court's order, was that the burden had not been met. And to state it succinctly, there is a contract between the parties that discusses liquidated damages. And that was the basis on which the court determined that there was an available remedy at law. And
there was a dispute as to what the damages were, correct?
Well, there was a dispute on multiple levels. One, it really wasn't a liquidated damages provision. It was a buyout, even though it used the words liquidated damages provision at one point of that particular provision of the agreement. It went on to say that the restrictive covenant is not released until $500,000 in immediately available federal funds are paid. And that's a buyout. And so,
except wasn't there a contention? There was an oral modification to make that. Like $1 million?
Oh, yes, sir. There was that contention. Again, that is not in any way, shape, or form sufficient to rebut the presumption both of irreparable harm and inadequate remedy at law, because that changed the contract completely.
Well, did it change the contract, or did it change the nature of this being liquidated damages, where the court was justified in saying it's still liquidated damages, but the amount needs to be determined in a trial?
Well, I don't think the court ever reached the question of whether the amount was an issue. The only argument that was made below was that we reached an agreement orally on May 6th, in which it was agreed that the practice would be paid through the collection of accounts receivables over the course.
So that begs the question. if hypothetically both sides had agreed, okay, it's $1 million and the $1 million get paid, would you still be arguing that you're entitled to a temporary injunction?
I would, Your Honor, yes.
All right.
And part of the argument is there's multiple reasons why that factually and legally does not rebut the presumption. One, Dr. Moulton, under the agreement, wasn't entitled to any receivables after the termination of his employment. Two, the agreement said very specifically, the restrictive covenant is not released until we are paid $500,000 in immediately available funds. Now, if their argument is accepted, that's a modification of the agreement because they're saying it would be paid over the course of 2 to 5 years through the collection of letters of protection. The other piece of that factually is that the evidence was clear. The amount of LOP receivables available at that time was $1,080,000. Dr. Moulton agreed that LOPs are collected at the rate of 45 to 50%, which means there's about $500,000 in available funds. Under his argument, factually, he was only entitled to 50% of that. That's $257,000.
Mr. Richards,
Yes.
the fact that a buyout or a liquidated damage clause exists in the agreement, does that bar the issue of whether there was irreparable harm?
No, Your Honor, it does not. And liquidated damages is consistent with the argument that your actual damages are not ascertainable. And that's the case in a restrictive covenant. That's why all the cases say injunction is the preferred remedy, because it is extremely difficult to determine. So those are not inconsistent. While the appellee argued in its brief and cited cases to this proposition, liquidated damages provisions operates to bar injunctive relief. They cited the Mayor's Jeweler case. That was a quote from a concurring opinion by Judge Farmer. And that's not what he said. He said, if it was up to me, in my view, he said, rather, I would hold that Article 20 liquidated damages provision operates to bar injunctive relief. That was not the holding of the court, and that's not the law of the state of Florida. They then cited the Sun Elastics case for that same proposition, that if you have a liquidated damages provision, and this is from their brief, there is by definition no irreparable injury. And again, they cited a concurring opinion of Judge Cope. 5 years later, in the Bradley case, we cited in our papers, Judge Cope wrote the opinion for the majority, and he specifically rejected the Sun Elastics.
There's also the argument that the presence of a liquidated damages provision tied to a non-compete agreement renders the non-compete unenforceable does seem to be a little bit circular insofar as you're basically saying parties at an arm's length contract just agreed and monetized a provision that the very act of monetizing it renders it unenforceable. Does seem to pose something of an interpretive problem if you think that if you're trying to hold to the idea that contract terms should all be enforced if they're otherwise clear and unambiguous.
Well, I understand that, Your Honor, and that is the specific argument that was made in the Bradley case. The employee there said that you cannot enforce by injunction a non-competition agreement that contains a liquidated damages provision. The same argument is being made here. And again, they cited the Sun Elastics case, and Judge Cope, who wrote the concurring opinion on which they rely and who wrote the majority opinion in Bradley, said, we reject this argument. Went on to say,
I don't want to interrupt you, but
sure.
You're saying whether it's a buyout or liquidated damages, you're entitled to a temporary injunction as a matter of law? Because there were no facts favoring your client put on below, except that Moulton violated the restrictive covenant from the get-go.
Well,
there's no accounts receivable that he didn't get. Their income didn't go down. He had the same level of practice. They, quote, worked harder. I mean, they didn't lose any business. The people that followed Moulton from Sarasota stayed with him. He had the need to provide some post-operative care to a couple of patients, and that's where the court went off on a public interest thing. But did the court have discretion to nevertheless deny the restrictive covenant on a temporary basis and flesh it out at the final hearing?
Well, Your Honor, I don't think so in the facts of this case, because what happened is not that he took a few patients, or he just saw them for post-operative care, or that we didn't have any harm. In fact, the testimony that was unrebutted was this. Dr. Joseph testified that the patients seen at the Safety Harbor office where Dr. Moulton worked declined significantly. His words. He testified that two of the primary referral sources, Dr. Cusimano and Dr. DiDio, their referrals had declined by 50%. And yes, he did testify, well, in our other offices, our patient populations have gone up because we worked harder, but they've all gone down at Safety Harbor, where Dr. Moulton worked. So there was ample evidence of harm. Just taking 85 patients. Dr. Moulton admitted, I took 85 patients with me. Now, those were not all post-surgery cases, Your Honor. In fact, there was surgery done in July of 2020, just months after he left. There was surgery done in October of 2020. There was surgery done in November of 2020, all on Joseph Spine patients.
I mean, just to be clear, of that number, weren't like 50 some under letters of protection that would have inured to Joseph Spine anyway?
Well, certainly Dr. Moulton testified to that, but that's not the way letters of protection work. There are multiple letters of protection issued to multiple doctors and cases. So, and besides that, Your Honor, even if we're getting the fees for that, that doesn't account for the non-monetary piece of this with regard to patients as referral sources. It doesn't account for him.
I think that's probably your stronger argument, is that you have referral sources and relationships that get damaged, and that's harder to monetize, which is why people enter into these non-compete agreements.
Well, and that's absolutely right. And that's why the case law is clear that by temporary injunction is the preferred course to enforce these, because damages are very difficult to establish. There's no dispute in this case that there was ample marketing done. There's no dispute that there was a significant and extensive referral network that was provided to Dr. Moulton. There's no dispute that he opened his office 1.8 miles from the existing office of Joseph Spine in Safety Harbor, that he did not resign his staff privileges at Meese Countryside, where he did almost 80% of his surgeries and is continuing to get patients through referrals there. And so there was extensive evidence, Your Honors, about the violations. Now, on the public health piece of this, since Judge Valenti raised that, I want to address that very quickly, because the argument that has been made has been addressed by multiple courts in the past. That what was argued below, what was argued in the brief, was that the trial court found that the public interest was more important than any of Joseph's business interests, because an injunction under these specific circumstances would interfere with a patient's right to choose his or her own doctor and aftercare. That very argument has been addressed and rejected. It was addressed in the Jewett orthopedic case versus White. In our brief, we filed a supplemental authority with the Eurocare versus Montfort case, where that exact argument was made. And there the court said, the record reflects that the sole ground cited by the trial court for denying the preliminary injunction relates to patient preference rather than the public health, safety, and welfare. And that case, as well as the Jewett case, referred to the Lloyd Dempsey case, which again is in our notice of supplemental authority, where the court found that it was proper to deny an injunction because there had been evidence presented of a compelling need for that surgeon in that area. There was no such evidence like that presented in this case. And in fact, the trial court only said that this presents a public health issue relating to patients' right to choose his or her doctor or aftercare. And that would be an argument that every surgeon would make if that was the law of Florida. What is required, and the reason we presented evidence below, Your Honor, is that there were no procedures that Dr. Moulton did that Dr. Joseph or other doctors at his practice could do. There was no skill set specialized that he had that other doctors did not have. Dr. Joseph testified repeatedly that there are a lot of spine surgeons in the area, and this is a highly competitive area. There was no proof presented of any medically underserved area, no community needs assessment, nothing of that sort to establish what is required, which is it would disserve the public health as opposed to a specific patient's preference or
Mr.
choice.
Richards, I just want to let you know you're at your 5 minutes if you want to keep going or save it.
Your Honor, I'll save that for rebuttal. Thank you.
All right.
We would just ask that the court reverse and order the entry of a temporary injunction in favor of the appellant. Thank you.
All right, Mr. Williams, you have 20.
Good morning, your honors. May it please the court. My name is Rob Williams and I represent the appellee, Dr. Andrew Moulton. We are here on this appeal in connection, obviously, with the entry of an order denying the plaintiff's motion for temporary injunction. This is a doctor versus doctor situation. All too often these days you see these things. But what is important, I think, given the arguments so far, is to go through the four-part test that a trial judge has to go through in order to determine whether to enter a temporary injunction, whether it be a physician case or any other kind of case. But I think physician cases are particularly acute, particularly given what's happening in this country today. With that said, we can all agree that a temporary injunction is an extreme remedy. At the trial level, I submitted a trial brief and I articulated a statement by a former Supreme Court judge who said everybody has the right to work. And of course, there's a constitutional provision.
Mr. Williams, how did your client rebut the presumption of irreparable harm?
Through Dr. Joseph himself, Your Honor, because Dr. Joseph conceded on cross-examination that whether you call it a buyout or liquidated damages provision, and I can go into that in more detail, but to Your Honor's question, Dr. Joseph testified that he himself inserted, it's paragraph 13H, I believe, of the employment agreement. There were 3 separate employment agreements, and that provision didn't change. He and I went through it in detail in his deposition, and I believe.
Okay, well, and there's this case. So there's the case of Bradley from the 3rd District,
right?
That says that a liquidated damage clause doesn't bar an injunction.
Correct.
Why should we not hold the same here?
Because Bradley is an apposite. And the reason Bradley is an apposite is because Bradley was decided under what I call the old statute. I'm 75, so I'll go back a few years. Under the old statute, that was the 1990 statute. The statute that governs this case is the 1996 statute. In fact, if I may, in Bradley, and I'll read it because it's right here. The enforceability of a covenant not to compete under the Florida statutes is governed by the law in effect at the time the agreement is entered into. The statute applicable here is section 542.33 Florida statutes.
And what about the new statute is different that would deal with a liquidated damage clause barring or not barring an injunction, other than that the law it's been revised?
I think that's a very relevant question, Your Honor. And the answer is really straightforward. In the footnote to that quote that I just made, the court in Bradley referred to the article that was written by John Grant and Tom Steele. Tom Steele was the author of that statute. Mr. Grant was the sponsor in the legislature. And if you read that article, and I commend it to everybody about these cases, the statute that was crafted by Mr. Steele and adopted by the legislature in 1996 was taken from the Happney case, which was rendered in 1990. The Happney case, as they say in that article, changed from the transactional approach to these cases to unfair competition cases. They then go in their article, say the starting point is the Florida antitrust statute, which mirrors the Sherman antitrust statute. And the question is, we need to get back, instead of just straight transactional equations, to unfair competition. Is it unfair? Is this unfair to the employer or to the seller of the business, as the case may be? And it's that change that I think answers your question. To go back to the facts of this case, let's go to Dr. Joseph's testimony. And Mr. Richards even alluded to it. I asked him a number of questions about his economic success since he fired Dr. Moulton. He fired Dr. Moulton without cause. He just fired him from the Safety Harbor office. They had 3 orthopedic surgeons in that practice. Dr. Moulton was the one at Safety Harbor. He testified that despite the pandemic and despite the fact that he had 1 less orthopedic surgeon, Dr. Moulton, who he fired, Dr. Moulton didn't quit, he fired him.
Well, he did give notice though, correct?
I'm sorry?
He was fired after he gave notice. He was going to open up a competing practice.
He was fired after Dr. Moulton believed that they had reached an agreement to disengage, but Dr. Moulton hadn't resigned, wasn't intending to resign, except if they went forward with this agreement that Dr. Moulton says they reached.
And
Dr.
Mr.
Joseph
Williams,
denies that.
the agreement that you're talking about is an oral agreement. The written agreement requires that any modifications be made in writing. But help me out with this. Your client did agree to specific performance, and that I believe it's paragraph 14 of the 2019 agreement, that the employee hereby acknowledges and agrees that any violation by him of any provision of section 12 or 13 shall cause employer irreparable harm and damage. It goes on to say that the employer is entitled to obtain injunctive relief. So your client did agree that if he violated any of the terms, that would be irreparable harm.
Your Honor's recitation of that language is accurate, and Dr. Moulton did sign that contract. I agree with both of those propositions. But as we all know, the fact that something is recited in a contract doesn't necessarily make it so. And that is particularly true when it comes to the extraordinary remedy of temporary injunction, particularly as it relates to depriving someone from his or her right to work.
Well, and Mr. Williams, you've kind of beat that drum a few times now about the right to work and that, you know, the viewpoint of competition and anti-competitive issues. And I think, you know, what your friend on the other side would say is, you know, look, the legislature balanced all that out for us. That's been baked into 542.335. It, you know, the statute says what it says, and what it says and what operates and what governs here is that there are presumptions that are put in place so long as the agreement is within these boundaries. And no one's making the argument that the agreement's more than 2 years or that it's an unreasonable in the geographic scope. I kind of, you know, I hear what you're saying, but it doesn't seem to me to align with the statute's text. And going to your point about the liquidated damages issue, I'm frankly just I'm struggling with that argument to the extent that was what the court relied upon because we don't really have detailed findings of fact in the order denying injunction. We just have the plaintiff didn't meet the burden of proof. So we don't really know how the court handled the presumption here. But I'm having a hard time understanding or accepting that, particularly in view. I know you've kind of pushed the bar case to the side, but I'd like you to address our court's Valak versus Hausinger case. And I'll read you the part where we held. In our view, the trial court misunderstood the statutory presumption. It is true that money damages were ascertainable as to some clients that Mr. Hausinger admittedly solicited, but the harm presumed under the statute includes the potential damage to Valak's longstanding relationships with its customers and the protection of confidential client information. Why doesn't that also address this case here and the concerns and the arguments that you're raising?
The specific answer to your question, Your Honor, is, I think, answered by this court's own decision in the Gerges case, the Surgery Partners Gerges case, which I frankly represented physicians in that case as well. In that case, this court, and I will quote from that because it is June of this year, the irreparable injury rule has 2 formulations. Equity will only act to prevent irreparable injury, and equity will act only if there is no adequate remedy at law. The two formulations are equivalent. What makes an injury irreparable is that no other remedy can repair it. Now, that is particularly poignant in this case because Dr. Joseph, under cross-examination, made it very clear that this clause for $500,000, 13H of the contract that his lawyers drafted, was his way of saying, if you pay me $500,000, everything's repaired. It's a compensation thing. That's his exact testimony. That's the quid pro quo. And that's the answer. So if there is an adequate remedy that can repair it, in this case, a monetary amount, then by definition, there is no adequate remedy at law, and therefore there's no irreparable injury at the stage of a temporary injunction. I think that answers Your Honor's question.
Well, but it goes back to the point that I made earlier, which is basically, so the parties just drafted a provision that by virtue of including the monetary amount of the provision makes it unenforceable.
At the temporary injunction stage, certainly.
But that was a bargain. That was a separate bargain for provision, was that they would be entitled to injunctive relief in order to enforce the restrictive covenant.
I don't think there's any case law in the state of Florida that stands for the proposition.
What my concern is that it becomes a, there really is there's no point in even putting it in, because really, if you think about it, the moment that you put in a dollar amount on that, you've now rendered injunctive relief off the table, which means that there's no reason to pay the $500,000 if that's true, right? Because the mere insertion of the term wipes out everything. If that were the case, then what you would have is really a novation. And that's not what you have here. All you had was a provision that attempts to monetize, hey, I'll let you out of this provision if you pay $500,000. You're trying to take that and leap with it and say, but the mere insertion of that price tag wipes out everything, and you can no longer enforce the injunctive relief component. So therefore, since you put that in there, I don't have to pay anything, which is kind of how this played out, right?
I respectfully, Your Honor, that's not what I'm trying to convey to this court.
But that's how it plays out. That's my concern. I understand you're not saying that, and I'm not suggesting you are. I'm saying that's my concern, is that you basically have put in in another context, you would call it a poison pill provision. That's not what this is, but no. You've put in a provision that has the mere insertion of it kills a significant part of an agreed upon contract. And the very price tag's insertion that does that because it makes it unenforceable, makes it illusory. There's no reason to pay for it if we accept there's no reason for your client to ever pay that $500,000 if this court accepts your argument.
Well, respectfully, I don't want to argue that point the way Your Honor has articulated.
I imagine not.
What I am saying, and I want to make sure that I am very clear in terms of Dr. Moulton's position here, is the insertion of that paragraph by Dr. Joseph does indicate, to go back to what I quoted from the Surgery Partners and other cases for that matter. Surgery Partners quotes Professor Laycock in his very seminal case on the death of irreparable injury. Okay, and really what that says is, in some ways, Your Honor's position may be correct, that if you have an adequate remedy at law, because you've agreed on it, and Dr. Joseph went through great detail about how he came up with it. Okay, so it's not a mystery in the record, and this is what the trial court heard. And so, if I may, if I can divert just a bit, Your Honor, back to the four elements that they have to prove in order to be entitled to a temporary injunction. Remember, and I know this panel certainly understands this, it's basic, the law of temporary injunctions. There are four elements, and you have the burden of proof. If you are the moving party, Mr. Richards' client is the moving party, you're the proponent of the temporary injunction, extreme relief, you have to prove every one of the four elements, all of them. If you don't prove one of them, you don't get your temporary injunction.
Mr. Williams, let me ask you this. Do you agree they were entitled to the presumption?
No, because we never get to that part, Your Honor, and here's why. Here's why. If you read the trial court's ruling, he makes a very clear ruling as to the first element. The first element is success on the merits. And he basically says that the plaintiff hasn't carried its burden of persuasion and proof as to the first element. Very first element. He says that that'll have to come at another time. Now, I don't want to get outside of the record, but as this discussion has already explicated, this is a much more complicated case than a simple contract. There's a lot more to this than we're talking about now. And I think the trial court recognized that. And he said, this is way too complicated for me to call balls and strikes as it relates to who's going to win and who's going to lose. There's a lot of other aspects. There are defenses that have been asserted. There's a counterclaim. And if you go back to the Bradley case stands for the proposition of the trial court in that case wouldn't allow the plaintiff the appellant in that case, Mr. Bradley, to get into his defenses and so forth. That's why the Bradley court reversed it right there. In this case, the judge says, we don't have enough time. I can't call balls and strikes because I've heard this is a longer trial and there's a lot more to it. So he decided that he could not reach a conclusion. And then when he doesn't reach the conclusion, then ipso facto, the plaintiff
Well,
has.
how was that a decision on the element of substantial likelihood of success, other than to say that I'm not going to reach the merits of that?
Because the plaintiff had the burden of proof, and I don't.
Yeah,
want
but
to
it sounds like the judge just passed on that element and chose to hang its hat on the irreparable harm and the public interest. Do you concede the public interest issue?
I'm sorry, ma'am.
Do you concede that the court erred on the public interest?
Not at all, not at all. And I'll get to that in a minute. But let me hopefully respond to your question. When the court ruled as it did, paragraph 2 of the order that was entered, denying the motion for temporary injunction, he essentially says you did not prove element number 1, the likelihood of success on the merits. Because, not to sound trite, tie goes to the defendant here, to Dr. Moulton, because this is an extraordinary remedy. And what the trial court was saying, I don't have enough evidence to be making that guess. I'm not supposed to speculate as to who might win and who might lose. So I'm not going to do it. I'm going to defer that. And he makes it very clear. These matters will be determined at a later scheduled trial on the merits of this action. Now, let me go, if I may, to your.
Before you switch gears, can I follow up with what you just said?
Yes,
Doesn't the transcript indicate the trial court probably concluded that Moulton satisfactorily rebutted the statutory presumption? So the statutory presumption was considered, and you have to overcome that in order to analyze the 4 elements. If you just get a presumption, then your client loses, correct? So your client has to rebut the presumption, and then the other side has to carry the burden on the 4 elements.
Well, I think the way the syllogism works, in my opinion, respectfully, Your Honor, is the question is, do we have a contract? And I addressed this earlier. We certainly have a contract. Dr. Moulton certainly signed it. It's in black and white. Whether parole evidence is necessary or not is another question. If you go to all of the other elements of this case, I will say to this panel that I believe that's going to be a big argument at the trial, whether parole evidence is necessary to interpret and apply the language of this black and white contract. Not unusual in any contract dispute. But to go to your question, the question of whether or not we get to the other elements, I think is answered if you don't get past the first element. You're not out of the batter's box. But if you are, you have a contract in black and white, both sides sign. Both sides sign. The next question is, so let's assume that is presumptively a valid contract. And I'm not really making that argument to this panel or to Mr. Richards for that matter. He signed it and he read it and he's a smart doctor, very highly trained doctor, I might say. But the next question is it enforceable? And if you go to the Grant and Steele article, it goes through that very carefully. If you go through the case law, it says that. And that's when you get to the other 3 elements. Is it enforceable? Is there irreparable injury? Is there inadequate remedy at law? I've addressed that previously, and I'm happy to expand on it.
I don't want to interrupt you, but you're technically down to half a minute. But I'm going to probably give you an extra minute just because we did pepper you with questions.
Thank you very much, Your Honor, and I don't want to abuse my time here. Let me address then the public interest issue. The public interest issue, I think, is very critical because we're talking about physicians and we're talking about human beings. We're not talking about salesmen. The classic decision out of this court is the atomic tattoos. I love the name of the case. I'm not a big fan of tattoos, but I love the name of the case. And in that case, the guy was at a tattoo parlor and he went down the street and sold the guy's customers. That didn't happen here. What he did was Dr. Moulton got calls from the surgery centers. Dr. Moulton, you've got these scheduled. What are you going to do about it? They were scheduled while he was at Joseph's Spine. Joseph fired him, overnight. And so Dr. Moulton had an ethical obligation to do something. And what he did was he contacted those few patients, said, Dr.
He didn't,
Joseph,
Mr. Williams, but he didn't have to put his office within the radius. He could have put his office outside the radius.
I can't argue that point, Your Honor.
Right. And he agreed to remove himself from staff privileges from several hospitals, and he didn't do that.
That goes to the enforceability of those contracts. And that's why I think the trial court decided to wait on that until we have a trial, because staff privileges at a hospital are between the doctor who's on the list and the hospital. Dr. Joseph has no right whatsoever to interfere with that. And when we go to trial, I'm going to establish that.
Mr. Williams, I don't want to interrupt you, but you've exceeded your time by a minute and a half. So I think it's time to say sayonara.
Thank you, Your Honor. I appreciate your courtesies.
Thank you. I'll give Mr. Richards an extra minute also.
Thank you, Your Honor. I'll be as brief as possible. With regard to the question of the Bradley case in 542.33 versus 542.335, that's a distinction without a difference. The standard remains the same. The other point is all the cases that are cited by the appellee to support the argument that liquidated damages prevents an injunction were under 542.33. So they're relying on those cases for themselves, but telling us we can't rely on our case for us. So that's not a distinction that makes any difference. The other point that I think is very important is that the contract says this is a buyout, but it also says, as Judge Smith and Judge Lucas referred, that we're entitled to injunctive relief, we're entitled to specific performance. So if you accept the appellee's argument, those provisions of the contract are meaningless. And the burden of the court is to give effect to all provisions, because that's what the parties agreed to. So I don't think there's any question that it was understood that having this provision in the agreement did not render injunctive relief unenforceable, which is the argument that's being made. They just referenced the atomic tattoo case from this court. That court said that establishing a breach of a restrictive covenant supports the determination that the employer likely will be successful on the merits of the case. There's no question that we established multiple breaches. Atomic tattoo specifically says that establishes substantially likelihood of success on the merits. The other issue, the public interest issue, this is very important. There are multiple cases that we've cited. The Ansari case, as an example, was a cardiovascular surgeon. Made a similar argument. The court said, no, you've agreed to these things. You violated it clearly. You opened your office a block down the road. We're going to enforce the injunction and the contract against you. If the argument can be made, which every surgeon can make, that the patient has a right to choose, continuity of care, the restrictive covenants will never be enforced against surgeons because they all can make the exact same argument.
Mr. Richards,
yes.
Mr. Richards, so if we send this back, doesn't the trial court have to revisit the substantial likelihood of success on the merits?
Well,
and we certainly can't make those findings.
No, I don't know that you can make the findings, but I think that that issue was established at the trial court level, and the court did not find and did not say we did not meet our burden on that. And the facts are clear that we did. That's why I started the atomic tattoo case. And again, in these cases, injunctions delayed or justice denied because this is ongoing. And the law is clear. There's no way to establish all the losses. It's just continuing. It's now been a year. And we had to go through 3 different hearings, partly because of COVID and getting time, but we're now a year out or more without any injunctive relief. And this is an ongoing harm. And that's why injunctions in these cases are so important. So I do believe that in this case, even if you accepted there was an issue about seeing patients or continuity of care, what you raised, Judge Smith, is correct. The court could have accommodated that interest if it was legitimate by saying, well, open 16 miles away or resign your privileges, because you don't need privileges to do follow-up care. You only need privileges to do surgery. And so there were a lot of things that could have been done, even with that presentation, to enforce the restrictive covenants to the extent necessary, which is what the court's supposed to do to protect legitimate business interests. Rather than doing that, the court just denied it outright and said, you're not entitled to any temporary injunctive relief. We presented evidence of bond amounts as the court requested. And so all the elements are there for this court to.
And so how then do we deal with Dr. Moulton's claims that he's entitled to X amount of money in looking at the substantial likelihood of success in the marriage?
Well, if you're saying Dr. Moulton's claiming he's entitled to money under the contract for the receivables that are collected.
Receivables, yeah, that are collected.
And that's a damage issue that he could certainly pursue if he believes he's entitled to that. But it's not a reason to deny a temporary injunction under the terms of this contract and under the terms of Bradley case, because what they're doing and what the court allowed them to do was just to change the contract and to say, no, you don't have to pay $500,000 as the contract says. And the contract is very clear. It says the restrictive covenant is not released until the practice receives $500,000 in immediately available federal U.S. funds. That's what the contract says. I believe it's paragraph 16. That never happened. And so what they asked the court to do, and I don't know if the court accepted this because the court didn't say, but what they asked the court to do was to accept a verbal agreement that Dr. Moulton, and he changed his testimony on what that agreement was between his deposition and the hearing, that he says occurred on May 6th, but he was terminated on May 7th. So there was no reliance on that agreement because it was the next day to try to suggest that there's some fraud or none of that was raised at the proceeding below. So there was no enforceable amendment of that provision for buyout. And so that's a preserved issue. If he wants to pursue it by way of counterclaim or otherwise, he can, but it was not grounds to either rebut any presumptions or to deny the request for temporary injunctive relief. And that's why we're asking the court, because this is such an ongoing harm to the practice, to reverse the trial court's determination and direct the entry of a temporary injunction. And now if the panel's concerned, well, it shouldn't be everything that we asked for. You could certainly direct to enter the injunction to the extent reasonably necessary, as the statute requires, to protect.
I don't want to interrupt you, but you're out of time.
Okay, I'll end there, Your Honor. I appreciate your time. Thank you.
All right, thank you, gentlemen. We're going to move on, if there's
Thank
no
you, Your Honor.
objection, to the last case, which is Solomon Law Group versus Dove and Mule Mortgage. All right, looks like both sides are present. Mr. Solomon, I believe you're the appellant.
Yes, sir. We'd like to reserve 5 minutes for rebuttal.
You got it.
Thank you, Your Honor. May it please the court. I represent my law firm, Solomon Law Group. Solomon Law represented Universal, the lender, a subsidiary of Lennar, in a residential foreclosure that we call the DeRuin foreclosure. That case went up on appeal, and this court reversed the judgment of foreclosure and determined that the case could not have been won at the foreclosure level because there was not a face-to-face meeting pursuant to the HUD regulations. And this court specifically identified the facts that were available and that have now been discussed in 3 separate appeals as to whether or not and under what circumstances the face-to-face meeting could have been required could have been waived, could have been performed, or could have been complied with. After the opinion came down from this court, the Dovenmule DMI hired the Ritter Cussett firm and filed a malpractice claim against our firm for failure to file a reply. To this day, they have not identified any facts or circumstances that would have changed the outcome of the underlying case. There are 3 appeals pending. This appeal relating to the dismissal of the counterclaim for the fees that we incurred and charged pursuant to the engagement agreement with Dovenmule as the agent for Universal, because they were the subservicer. There's also an appeal pending regarding the final summary judgment that was entered by the trial court in favor of Solomon Law on the malpractice claim. And then there is an appeal relating to the trial court's denial of attorney's fees to our firm on the basis of 57-105 and on the basis of 768.79. We represented Universal in the residential foreclosure. DMI was merely a shepherd for Universal. They were the paymaster for fees charged to Universal for Solomon Law to represent Universal. And pursuant to that, there was an engagement agreement that was entered into. The engagement agreement is not a contract separate and apart from the malpractice claim, because DMI could only sue Solomon Law because it was the shepherd of the foreclosure case under the engagement agreement. It was not the party to the underlying foreclosure, and we raised standing at every single juncture during this case. And because there was this engagement agreement, the trial judge deferred ruling on our objection to DMI's client status and ability to serve as a plaintiff in a malpractice claim. But that was DMI's argument. They have the engagement agreement. The engagement agreement is pursuant to which Solomon Law was retained. So how can now DMI claim that the contract is separate, that the engagement agreement contract is separate from the malpractice claim? It is, in fact, the basis upon which DMI could possibly obtain, we still challenge, but could possibly obtain any standing to sue for malpractice. The contract provided any basis for a malpractice, and it was relied upon to overcome the standing. Without the benefit of the engagement agreement, DMI would have no claim whatsoever to assert. So where does that leave us? When they filed their malpractice case, they owed us some $67,000 in fees, and we have to beg for every nickel the way these residential foreclosures are done. So each of those fee requests was submitted and approved, but now they decided that they weren't going to pay it. We had discussions regarding the malpractice claim, couldn't dissuade them not to file the malpractice claim, but when they did, and they chose Hillsborough County as the forum for the malpractice claim, they created a 1.170 problem, because arising out of the same transaction and occurrence is the underlying fees. And the Alan Knutson case and a whole slew of other cases make it clear that the claim for fees and the corresponding malpractice claim are mirror images of each other and constitute a compulsory counterclaim under 1.170. So the only question is whether or not this court is going to adhere to the standard rule that says that that at the end of the day, procedural matters are dictated by the forum. They chose the forum. They came here. It's not a jurisdictional issue. There's no question that the Florida court has proper in personam jurisdiction, proper subject matter jurisdiction, and no challenge to jurisdiction was made in connection with the malpractice case.
So they're saying as a matter of law, you're required to file your counterclaim as an initial action in some other jurisdiction, I believe Illinois or something?
Correct, in Cook County in Chicago, Illinois. And they're saying that we don't dispute that forum selection clauses are valid, generally speaking. The law that we have identified under NAHAR, under the restatement second for conflicts of laws, and every authority that we can identify puts the 1.170 procedural matters of the forum state ahead of.
So the other side could have filed in Illinois to begin with.
They could have filed. We would have had very little to object to. in that basis. They could have sued us under the contract. They could have sued us for malpractice. They could have sued us for antitrust violations. Whatever it was that they wanted to file against us, they could have. And they raised all of those issues based upon their mooring to the engagement agreement. And they themselves ignored and abandoned that forum selection clause. They could have required us to go to Illinois, but they chose to litigate here. And that raises the issue of the compelling considerations that the law says should be discussed and considered when determining whether or not there should be a procedural override of the contractual provision, because
Well, Mr. Solomon, before you get into that's an interesting issue, the procedural override component. I want to focus kind of more on a first principle issue that ties it. You all touched upon this in your brief, and I'd like to hear your thoughts on it, which is we know that it's interesting. If this had been we know that if an original action, or excuse me, a counterclaim had been brought when an original action had been filed outside of a forum selection clause provision, that the counterclaimant would have been deemed to have waived the forum selection provision in all likelihood, much like we know this because that's how it plays out with arbitration. That's how it plays out with personal jurisdiction arguments, that basically if you don't make that your first assertion in the litigation, you've waived it. And there's a lot of cases that hold that. This seems to me to be even more so because you have the initiator of litigation going against a forum selection clause that they are now seeking to enforce. So I'd like your thoughts about waiver and about how we should construe that in this somewhat unique context.
Thank you, Your Honor. I think that that's a key point in this case, because they had the right to file suit in Illinois should they have so chosen to do so. The case was also filed, the underlying malpractice was filed in a different circuit. They could have filed it even in Pasco County, where the underlying DeRuin foreclosure was conducted. They chose not to do that. And in fact, this was a discussion that Mr. Rosner and I actually had before the lawsuit was filed. I said, I'm going to have to file my counterclaim for fees when you file your malpractice claim, because it's going to be a compulsory counterclaim. And knowing full well that it was a compulsory counterclaim and had, by definition, as a compulsory counterclaim, we would have been remiss if we were representing a client. A client certainly could have complained that we didn't file the compulsory counterclaim under 1.170, because no other parties, no other issues needed to be added in order to make to put everybody before the court. But they chose affirmatively to sue us here, for what reason I still can't figure out, rather than make us go there. That compelling consideration, coupled with the fact that the claims asserted in the counterclaim are compulsory in nature and not just permissive in nature, shows that this is where they wanted to file and litigate all of those claims. They turned it into a jurisdictional issue, and the trial judge bought that. And this is just flat out not a jurisdictional issue. It's an issue of compulsory counterclaim and their waiver of any provision of that contract.
Just to interrupt for 1 second, I think the judge may have focused on the word irrevocably in the agreement. Is this an irrevocable agreement that cannot be waived?
I don't see any provision in this agreement that can't be waived.
So the use of the word irrevocably doesn't change your argument at all?
No, sir. No, because under the circumstances here, they focus in their answer brief on the fact that provisions can be waived, provisions of the agreement can be waived, and we agree with that. Constitutional rights can be waived under the appropriate circumstances. It's not like they didn't have lawyers identifying the requirement for a compulsory counterclaim, and that when they addressed that, they chose to try and dismiss it based on jurisdiction, not based upon my second issue that Judge Lucas stopped me from addressing, which was really the issue of the procedural override when they picked this forum, they chose this forum's procedure, the mechanics in which this state and this court, this trial court is obligated to conduct its business is what they voluntarily submitted themselves to. And there is no other reservation. It's not like, oh, we're going to sue you here, but we're going to carve out anything that's going to make it compulsory, or we want your agreement that this is not a waiver. There's nothing in the agreement, in this massive one-sided agreement, that they could have put anything in, that they didn't put anything in that says that this is not, that provision is not waivable. Under the circumstances, we have that come up in franchise agreements and the difference between arbitration and litigation all the time. And those provisions are waived by the first forum selection made by the plaintiff. And when we tell people in family law cases and in other cases, it doesn't matter who goes first, everybody's going to get their say. It's not a jury trial. But under these circumstances, that made a difference because they chose the forum and put us into a catch-22 situation that we had no choice but to follow suit with the compulsory counterclaim. And now to say that after we complied with the requirements that they caused to arise in this case, then somehow the court doesn't have jurisdiction to litigate. Their argument is based upon the fact that there is some distinction or some dichotomy between this engagement agreement, which is the second argument in their answer brief is something that was lost on me. I really don't understand how that could possibly be if you need the agreement to create the malpractice standing in the first place. How do you then say it doesn't relate to this and you can't therefore tell us we waived it? As far as the other issue, I hope I've addressed that issue, but the procedural override, we take great pains in this state to deal with our procedural requirements. And I think we're on the cutting edge of things across the nation in terms of what we're doing. This compulsory counterclaim rule doesn't exist in federal court. They might have been able to sue in federal court. The amount in controversy was in excess. There was complete diversity. They could have gone to federal court, but they chose not to. And there's no compulsory counterclaim rule in federal court. And there's no compulsory counterclaim rule in Illinois state court. They could have sued us there and challenged our ability to pursue that. They could have perhaps asked for a bifurcation to wait until. This bleeds over into the other issues in the case because with respect to the nature of the release that we asked them to execute, it's a different appeal, of course, relating to the attorney's fees and the offer of judgment. But we said, when you take this offer of judgment to settle the malpractice case, we don't want to relitigate the malpractice issues in Illinois. And therefore, we had to put into the release that says, hey, all of the stuff that's going to be resolved by this settlement or proposal for settlement that's accepted are going to be resolved. We're not going to pay you something under an offer of judgment and then have you go and relitigate those issues. These issues all had to be litigated here in this forum because that's where they brought the issue. They could not very well have expected to sue us for malpractice and not have us complain, well, but you didn't even pay us for the underlying case, particularly when now we know we were right. And to this day, September 15th, they have yet to say what could have been done to resolve the issue in the underlying case and allow Universal to win.
You got your 5 minutes, but you're welcome to keep going.
My last comment in that regard is they had certainly every opportunity to make a distinction, and they chose affirmatively not to do that. Under NAHAR, under the restatement second, and to the extent that any of these analogous areas are applicable, we have compelling considerations that allow the override or the precedence of our procedural rights, our procedural rules. And since we had no choice but to file it under the circumstances, and they knew we had no choice but to file it, they're stuck with it. And therefore the compulsory counterclaim exists. And because of the general rule that we couldn't appeal the denial or the dismissal of the compulsory counterclaim until the merits of the case were resolved. That's why we're so far down the road, or it would have been resolved all at the same time.
All right, I'll save you the 4 minutes that you have left.
Thank you.
Mr. Rosner, you've got 20?
Yes, good morning, Your Honors. If it may
Morning.
please the court, Gary Rosner on behalf of the appellee DMI. Your Honors, if it pleases the court, I am just going to stick to the issues raised by the brief before us today and not address the summary judgment or the other pending appeals or the facts involved. I'm just going to stay with the counterclaim, which is the subject of this morning's appeal. Your Honor, there is, as you said, I believe it was Judge Volante, you asked if there was an irrevocable clause, if it was irrevocable. The answer is yes, it was irrevocable. We filed suit in Hillsborough County. We did not file under the contract. We filed for breach of fiduciary duty and negligence. I did not attach the contract. I did not sue for breach of contract. Mr. Solomon had every right when I filed the suit. He could have moved to dismiss and said, this isn't where we should be. Apparently, he was pleased with where the jurisdiction was, and he went and filed his counterclaim in Hillsborough County. He attached the contract. He now made the contract an issue. We moved to dismiss. It was granted. There was a rehearing. It was the rehearing. We had a full rehearing on it. The judge again affirmed her previous order. Judge, what I want to talk about is, and I think where we're going here is first of all, in the cases that have been mentioned in the brief by Mr. Solomon's firm, I don't believe any of the cases that he is citing, with the exception of an Illinois case, talks about when you have a retainer agreement. What he talks about is compulsory counterclaims. Now, the compulsory counterclaim.
So just to be clear, you're casting this as a permissive counterclaim, or it wasn't either permissive or compulsory?
It wasn't permissive or compulsory. He could have brought it where it was because, as we know, the venue selection clauses, as the case law states in the briefs, is presumptively valid. This is not a case. What could have happened here, and I'm going to read from a case, and this is because I know where this is going, and I believe I know where it's going in terms of inconsistent verdicts and what would have occurred if he would have sued in Cook County and we sued down here, and what defenses or what might have been brought up in Illinois. First, I'm not admitted in Illinois, so I cannot speak as to what defenses there would have been brought for breach of contract and open account, which I believe were the two counts stated in the counterclaim. We did not sue, as I stated, we sued on tort. In the case that we cited, and it's Whitman-Hart, the CA Inc. and NICU, and that he cited. The 402 that Mr. Solomon cited, his own case. He cited an Illinois case, 402 Illinois App 3D 848. And essentially, if you look at that case, what was written in that case is turning to the first factor. Courts of different states having concurrent jurisdiction over a controversy may both proceed simultaneously in one court until one court reaches judgment. Under the principles of comity, one state may stay or dismiss the pending proceeding before it out of respect for the other state's law and judgments. So taking the Illinois case alone, what could have happened is he could have gone to Illinois with the case. He could have asked for a stay. He could have asked this court to stay, because just because you have concurrent jurisdiction doesn't mean that you can't go forward. Mr. Solomon, what he should have done if he didn't like where we brought the lawsuit based on tort, he could have moved to dismiss. He didn't move to dismiss. He didn't raise it as an affirmative defense. I'm not going to get into the standing issues because that's not why we're here today. There are two, as Mr. Solomon said, there are other pending appeals. They did not raise it as an affirmative defense. They did not move to dismiss the counterclaim. Rather, they took their cause of action for fees that they allege are owed, I believe, since 2019, and they decided they were going to sue on the contract in Hillsborough County.
Well,
Mr.
going
Ross,
back,
go ahead.
I'm sorry, go ahead,
Mr.
Judge
Chris.
Smith.
I'm sorry.
My question is, as to the form selection clause, how can you say that for example, the breach of fiduciary duty doesn't arise out of the retainer agreement? I mean, the form selection clause uses the language any matter arising, and then it puts from or in connection with this agreement. So how can you say that the fiduciary duty doesn't arise out of the agreement?
Okay, because under the case law, Your Honor, a legal malpractice claim is a personal claim. The breach of fiduciary duty claim is a common law tort, and we sued in a common law tort, not under the contract.
No, I understand you didn't sue under the contract and that you didn't attach the contract, but for the legal relationship, you don't have a fiduciary relationship. Would you not agree?
Well, Judge, no, I wouldn't agree to the extent that even without a retainer, as I'm sure the court is aware, in a contingency case, it's required that you have a written agreement.
So you're drawing the distinction that because it's a retainer agreement, that it's different.
What I'm saying is, Judge, is that because we sued under breach for common law torts and we didn't sue under the contract, and there could have been concurrent jurisdiction that Mr. Solomon, he waived it. He could have. Subject matter jurisdiction, not waivable. Personal, waivable. Venue, waivable. Mr. Solomon's firm did not ever bring this up when we filed the lawsuit. Never. I don't believe in the.
But what about the point, Mr. Rosner, that you're purporting, if we accept the notion that your torts only arise because of this relationship between your client and the Solomon firm, which is memorialized in a contract that you're now seeking to enforce, that your client was the first one to breach this purportedly irrevocable venue provision. What are we supposed to do with that?
Judge, what we're saying is that, again, and I don't want to be redundant, and I apologize if I am, is that we are not suing under the contract itself.
I understand, but for purposes of my question, just assume for a moment, and I'm not holding you to this, but just assume for the moment that we would find that these are claims that arise out of this agreement, fairly interpreted under 21.7 of the paragraph. Whether or not they are direct contract claims, for sure, they're not. But if we were to assume for this question that they arise out of the agreement in a meaningful way, wouldn't your client's filing here in Florida constitute a waiver of the form selection provision they're now seeking to enforce?
Okay, so with
that assumption,
I'm going to make the assumption, Judge. Okay,
yes.
But obviously, I'm not going to agree with the assumption.
Not holding you to it.
I'm going to take the assumption.
Road clearing and caveats
Yes.
galore. Yes.
Excellent question, Judge. Yes, the answer would be yes.
Okay.
We waived it. I would
Okay.
be remiss, or it would not be forthright of me to say we didn't waive it. However,
I appreciate the candor in that.
Of
So
course.
this really does boil down to the discrete issue of whether or not there is a relation between the claims that you all brought in Hillsborough County versus
Yes.
the breach of contract. Okay.
So, okay, I'm sorry, Judge. Can I?
No, that's it. That's it.
Okay, so Judge, and what I was going to say is the issue is that, again, while we may have waived, Mr. Solomon had the right to move to dismiss, and he chose not to do that. He chose to bring his counterclaim here, and he sued under the contract. And I understand this is really cutting hairs, but he decided, their firm made a conscious decision not to dismiss. He could have gone to the judge and said, you know what, Rosner's wrong. He shouldn't be here. We should be up in Illinois. But as I cited from the case law in Illinois, and again, Your Honor, I don't want to, Justices, I'm not an Illinois barred lawyer, so I don't want to make any assertions as to what Illinois would do, other than that I obviously can read the case law that's been cited. And what Illinois is saying is, you can have concurrent jurisdiction, and that's what comedy's about. He could have filed He didn't even have to wait this long. He could have gone right up to, he could have gone to Cook County, filed his lawsuit, and then there may have been an ask for a stay. I can't comment on that because I don't know what defenses or what would have been brought by an Illinois law firm in defense to an open account breach of contract in that state. What I can say is, Your Honor, is that we chose not to ignore it when he sued on the breach of contract. And it's our position that we sued on independent torts. And as I said, while his case law cites to counterclaims and compulsory counterclaims, I don't believe, with the exception of the Illinois cases he's citing, that any of the cases he's citing deal when there's a written retainer agreement or of any type of forum selection clause. He's strictly relying on a compulsory counterclaim.
Well, did the trial court make any findings in the verbal findings? Because the order is pretty skimpy, that there was no relationship between the contract and your client's cause of action vis-a-vis the counterclaim being compulsory or not?
Judge, if you can bear with me a moment, I believe we have the transcript here, and I can take a quick.
I read her ruling, her verbal pronouncement to be under the impression that she just didn't have jurisdiction. But
On the
maybe there was something else that she said that rounded that out, but that was my takeaway.
I've got the transcript right here. What she did ask at the hearing when we had, I believe it was at the rehearing, she said to Mr. Solomon's counterpart, colleague, Ms. Howard, I want to know if you have, I do understand that's what the gist of the argument is. Is there any case law or any authority that you could show me about the situation in which the choice of law provision is another state, not just another circuit or county in the state of Florida? I'm concerned about that. The answer was, well, Your Honor, it doesn't. I couldn't find anything. I couldn't even find anything in federal law. The court then went on to say, I don't know that I have jurisdiction over the claim. That's my question. If the choice of law provision with regard to actions from the contract is Cook County. And essentially at the end, the trial court upheld again their prior decision, the initial decision, which was that the trial court believed, I believe it was Judge Peacock said, we don't have the jurisdiction on the counterclaim.
That's just an incorrect statement of the law, right? What vis-a-vis for, I mean, I'm looking at the Manrique versus Fabry case, the Florida Supreme Court case from 1986. And the court explained forum selection clauses do not oust courts of their jurisdiction. It gives them an excuse, it gives them a way or a means or it gives them a way not to exercise their jurisdiction because the parties have contracted otherwise, but it neither confers nor withdraws jurisdiction from the court because it can't.
No, I think well, I know what ended up happening here is that it was clear that, at least from my review of when I read the transcript again, is that what the judge was saying is you do have this irrevocable clause. You sued on the breach of contract, and I'm not going to take jurisdiction of it. You have an irrevocable clause, and it's going. That's it. It's dismissed. And we had 2 full hearings on this.
So you don't agree with the proposition that if the judge said, I don't have jurisdiction as a matter of law, and never considered whether your client's claim arose out of the agreement without attaching it, you don't agree that would have been a permissible way for them to file a counterclaim?
I think what
let me ask it this way.
I'm sorry, Judge. I'm trying
it's probably confusing. Let me ask it this way. If the complaint attached the agreement, would you still be contending that they didn't have the right to file a counterclaim, compulsory or not?
I would say that we still had the right, compulsory or not, to move it to file that motion to dismiss. And I'm looking, if I may, Your Honor, because there is on page 17, the court does give a further explanation of why the court found the way it did. And if
All
I
right.
may, just
What do you got?
she goes, okay, I'm going to distinguish, Miss Howard, the ruling that I made in the other case, the name of which escapes me, but I recall what it was. And the difference was that the venue was appropriate in either place. I believe venue is not appropriate because the parties contracted to a choice of law. The contractual provision says jurisdiction of the claim and venue in Cook County, Illinois, and that's what I'm concerned about. I think that contractual provision negotiated by the parties moves this to a different place than both having appropriate jurisdiction in the circuit courts of Florida. This claim has appropriate jurisdiction only in a state or federal court in Cook County, Illinois, is what the parties contracted to. I don't doubt that it's a compulsory counterclaim under Florida law, but I think because you contracted, your client contracted to have that in Cook County, it is different. So I am inclined to grant the motion.
But you just said something that doesn't help your case.
I understand.
But it's being honest. If the judge actually found it's a compulsory counterclaim, that's kind of a finding of fact that we can extrapolate that it's related to the contract, et cetera, which is, I think the entire panel's been concerned about that aspect. So if we get away from the fact that this was simply a matter of law, but it was related to the contract, then who had the burden to transfer this case? Was it your client or him? Normally you'd file a motion to transfer it, to send it someplace else, but you kept it in here at the risk that they were compelled to file a compulsory counterclaim. So I'm confused as to what the trial court really did in this case.
Yeah, and Judge, again, and like I said, and I'm full candor, that's why I'm reading exactly where, when you asked, I believe Judge Lucas,
I appreciate
it was Judge Smith, someone asked, and in full candor. And again, it just goes back to my argument, and I understand what the panel is asking. It's our contention that Mr. Solomon, forgetting the compulsory counterclaim, there was an irrevocable clause in there for Cook County, Illinois. When we filed our independent tort claims, he could have, when he brought the breach of contract, he could have said, no, I want this going up to Illinois pursuant to it, and he waived that.
But he didn't do that. So he accepts an implied waiver. He could have required you to transfer this case to Illinois.
Yes, but I don't believe that would have required me, if he's suing under the contract, to then do that.
Well, you could have taken a voluntary dismissal and refiled in Illinois, but that didn't happen either.
No, that did not happen.
Okay.
We moved to dismiss and said that the money part on the breach of contract should be going up to Illinois.
We've kind of interrupted your flow, and I didn't mean to, but you've got about 2.5 minutes left. You want to get back on track wherever you think you need to cover.
No, Judge, I think we've covered it all. I've tried, I'm always candid with the judiciary. I know this is sort of a splitting hairs situation, but I believe at the end of the day, what should have happened is Mr. Solomon's firm should have filed the motion to dismiss instead of filing the answer affirmative defenses and counterclaim. I presume probably because he was happy that it was in Hillsborough County, but I don't believe
he's a Tampa lawyer.
Yes, so I assume that he would be happy that it was in Hillsborough. And we made that choice, but I don't believe when he brings the contract into play and doesn't do
Well, I mean,
anything.
honestly, here's my assessment so far. You're using jurisdiction as a sword and not as a shield. I don't think what's good for the goose is good for the gander in this case. You can't make that argument. You either all in or not in. You can't come back and say, we can file, but you can't file. It just seems innately unfair, but I'm going to reserve my final thoughts until we have a discussion.
And just briefly to the whole panel, and Your Honor, that was one of the things I sort of anticipated was going to at some point come up. So I expected that the sword and shield to come up at some point here.
Wait, you got the sword right behind you.
I know. I have the sword right behind me. So while I understand that argument, Judge, again, I would just reiterate, I believe once the breach of contract came in, the onus was on Mr. Solomon. He could have moved to dismiss and move it up there. You have the Illinois case, which says we could have had comity because on the fee issue, I don't know what defenses would have been available up in Illinois. We sued on the independent torts of negligence and breach of fiduciary duty. Unless the panel has any further questions, I'd respectfully request that the court affirm the order.
Thank you very much. Mr. Solomon, I said you had 4 minutes left, right? So you still
Thank-
got 4.
Thank you. I'm not going to use all 4, I don't think, unless you have some questions, but I did want to make a couple of remarks if I could. One is Mr. Rosner says kind of gratuitously that the onus was on us to move the case once we decided that we were going to pursue our claim for the fees in the underlying case. I don't know any precedent for that, why the onus is on us. They picked the forum, and yes, we were delighted with their choice of the forum. And I saw no reason to change the choice of the forum from my home court to go up to Illinois, whether in the summer or in the winter, and that takes care of that. As far as this irrevocable issue that Judge Lucas raised and that Mr. Rosner glommed onto, I don't see that there's anything irrevocable about that provision in the contract or in the law. So I don't know why it would be irrevocable. If it would be irrevocable, that would have to be some strong language that would otherwise eliminate the ability to make a waiver. And certainly in this case, they are sophisticated plaintiffs with sophisticated counsel, and nobody was doing anything underhanded. I also want to point out, I think unfortunately Judge Peacock was a little confused. And when she looked at the provision of the agreement, and she said that that the parties irrevocably consent to the exclusive jurisdiction, I think she then decided that jurisdiction was something that the parties could confer or could have some impact on. And as Judge Lucas points out, that's just not the way it works. And since we don't have any problem with either subject matter or in personam jurisdiction in this case, that's a misnomer, and it should be not jurisdiction at all in terms of this exclusive jurisdiction. It would be within the exclusive authority of the court to address the case. And if there were jurisdiction otherwise, then the Illinois court or the Florida court or the Arkansas court could address it. Last point I wanted to make was that the language of the provision itself is so broad, and it's essentially the same. I know Mr. Rosner didn't want to talk about the other elements of this case, but it's one group of litigants with one group of cases with one group of issues, and they complain about the breadth of the release language that was included in our proposal for settlement because it dealt with matters arising from or in connection with, and that's precisely the same language that's in this provision. If what's good for the goose is good for the gander, certainly the work that we did, whether it was good, bad, or indifferent, was something that arose from or was related in connection with this agreement, because it's the only basis upon which Dove and Mule could have been involved in the case. Otherwise, Universal would have to be the plaintiff complaining that they, in fact, did not get their proper service from us as lawyers. And the reply that they are complaining that was not filed, we've begged, borrowed, and stolen from every which way we could possibly do to find out what was it that we would have pled in reply to all of this that you're now complaining we did not do properly.
You have 20 seconds left.
We didn't reply because there was nothing to reply, and we gave them every opportunity to figure out what can we say in reply to the fact that you didn't even assign the case to us until the period of time under the HUD regulations to conduct the face-to-face meeting had already elapsed. Thank you.
Mr. Solomon and Mr. Ross, I want to thank you both. You're both out of time. We're going to recess now. We've concluded the Zoom meeting, so we're going to sign off. Have a great day, fellas.
Thank you for your time. Thank you.
Thank you.
Mr. Solomon, have an easy fast.
Thank you.